Hearing board meeting. Nine 30 a.m. on time for the meeting of the South Coast Air Quality Management District Hearing Board. Let the record reflect that there are 3 members present. We do have a quorum and we're going to proceed. We need to provide the oath. Are you the court reporter? Okay. All right, so we will provide you. She takes the oath, right? No, okay.
And Chair Ali, this is Dr. Abraham. I'm on the line.
Okay. Okay, well, we have 4 members present and his meeting was properly posted. Okay, very well. Just want the record to reflect. Okay. All right. So what we'll do is we'll go ahead and we're gonna wait to commence the hearing until 9:35 or so. But in the interim, uh, there was some discussion around continuing this hearing to tomorrow. That may be a challenge for some. So if we can try to get through as much as we can today and then return on the 27th. When we return on the 27th, there's another potential challenge because there's a hard stop at 2 p.m. for a hearing board member on the 27th. If at all possible, I would really encourage us to focus on the areas of concern where there's conflict or there's disagreement. There's a document, there's an exhibit that's within the file, which clearly delineates the distinguishing differences for which both parties find contention or contentious, rather. And so if we could stick there, we can potentially move through and try to land this plane today. It'd be very nice. I know Ms. Morgan has a vacation. She wants to try to enjoy the end of summer. And so we want her to. And so we'll recess for a second and then we'll come back and we will convene around 9:43. We're off the record day. Sorry, Day. It's Kevin. How you doing, Kevin, my friend? Good morning.
Good morning, sir.
All right. Just want to make sure I give you some love, pronounce your name correctly, and who you really are. Dr. Abraham? Okay, I know we said 9:43, but it's 9:37. Kevin, we're going to go back on the record. Okay, we said 9:43, but it's 9:37. We're back on the record. And so our good friend, Mr. Israel, was in the process of being questioned by members of the board. Ms. Roberts?
Yes, can I ask that witnesses be resworn? I also have an additional witness that I would like move over to panelists, Dr. Andrea Polidori, for taking the oath. But I also just had an inquiry from our public affairs staff. There are a number of members of the public, and is the chair's preference to take that if they have either comment and or testimony at the beginning or the end of the hearing?
Well, we took testimony Saturday, so at this point, we were going to proceed forward.
So I believe if they were not in attendance and didn't thus have the opportunity, I do think they are still allowed to have testimony. If they have already provided testimony or were in attendance and chose not to, then I don't believe they are entitled to provide testimony or comment.
Okay, we'll take the testimony and the comment at the end. And so I just want to be clear, that's a privilege, but the way in which our agenda is constructed and the way the code reads, audience comments, public testimony is taken at a certain portion of the meeting. But today we really want to get through. We want to provide the oath for your expert witness who's coming on via Zoom, correct, Ms. Morgan?
No, our witnesses are all here today.
Okay, very well. Okay, I thought someone was coming via Zoom. Okay, so we're going to go ahead at this moment in time. We're going to administer the oath. Is there an interpreter, just for the record? Madam Clerk, no interpreter, correct? Okay, very well. All right, can we move?
Dr. Polidori has been moved to panelist.
Okay, very well. Can we bring him up on the screen so we can see him? Kevin, can we show the good doctor? Okay, there he is, Dr. Polidori. All right, will you raise your right hand, sir? Okay, repeat after me. Well, no, I'll say it and you'll agree. Yes. Oh, we're going to re-swear everybody else in? All right, fine. Do you solemnly state under the penalty of perjury that the evidence that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
May let the record reflect that all in attendance as well as via Zoom agreed, concurred, and they are officially sworn in to be able to provide testimony during today's hearing. Okay. Mr. Israel, I believe Mr. Balaka Palan was teed up to and ready to go.
The district would redirect to move this along for board questions.
Yeah, that's what we said Saturday. All right, okay, Balaka Palan has the floor.
Morning. Morning, Mr. Israel.
Good morning.
I think I sort of brought up last week. Do you have any data to provide to to me, at least to the board, about the breakdown of the type of complaints received? Let's say, for instance, the last hearing, based on trash odors, reaction area odor, landfill gas odors, that indicates there was a, what the breakdown is on that.
Well, I didn't have a lot of time to review because it was over the weekend, so I don't have anything formally to present to you at this time.
But the hearing was noticed for last Saturday, and so you didn't prepare for that Saturday hearing with the data?
No, other than the questions that were asked by counsel.
Okay, so you were not prepared. So if you don't have you said you reviewed the data, and I'm not disputing it, but without having hard data to look at, because there's some conditions that have been proposed. For instance, not accepting any trash between certain hours, correct?
Correct.
And where's the data to substantiate that? Showing one, that the wind is blowing in that direction, the number of complaints, in the early morning, high, what's the impact of that diversion to a later time? Do you have any kind of data to substantiate that this is an effective methodology and, to do that and and how long? I think you mentioned in the last hearing until the next status hearing, but I'm not sure when that status hearing is, and the other, and I'll stop. I have some follow-up questions on that. So do you have any wind data? Let me put it that way first.
So I don't have anything to present to you, but I did, before the hearing, did review all of the complaint reports that were written for notices of violation that were issued where trash odors were confirmed by the inspectors.
And I'm not disputing the trash orders because there are different kinds of orders they were during that period, right? Let's say the 84 notice of violation that were issued since the last status hearing. I believe there are 84 notice of violation, correct?
Since the beginning of April.
Since the beginning of April. And the breakdown on that was not only, the orders were not only limited to trash orders, correct?
That's correct.
And what percentage would you say, based on your review, was limited to was based on trash orders versus the landfill gas and reaction gas and so forth?
Well, in my review, since the end of April, since the last hearing, there are approximately 21 notices of violation that were issued for nuisance where the inspectors described trash in the community.
Okay. 21 out of the 84?
Correct.
Okay. Oh, I'm sorry. Yeah. Okay. And did they also, do you know the time of the day when those were detected?
Yes.
And what is it?
The violations were issued for morning hours, typically before 10 o'clock in the morning was the general number. And also the wind, since you asked about that, was typically between 0 and 5 miles per hour from the south, southeast, and occasionally from the southwest.
And there were a number of conditions on the existing order to address trash odors. Will they been implemented?
The what we've noticed is that with respect to they've got a misting system installed and that they're operating tow and blow and orchard fans in the working face area. Are you referring just to the working face or just odors throughout the facility?
No, I'm talking about the trash odor because I think the change in timing of is based on the trash odors because it's early morning.
Correct.
So I'm specifically focusing on that right now, the trash odors.
Okay. So they've been doing that consistently, using the equipment like that to help mitigate odors in the working phase.
And are they not effective?
Well, we're still getting odor complaints and trash odors specifically on occasion, and those were being verified by our inspectors.
Right. I mean, the trash odors has always been there, correct?
Correct.
And what happened at based on the ETF conditions, we had you're getting complaints based on the conditions related to the ETLF, correct? The elevated temperatures, and so you had the reaction gas odors and so forth.
Correct.
Right. So did they then shift focus to that and not focus on the trash odors, or were they trying to handle all of them?
Well, the landfill is trying to handle all of them. We were focused primarily on the reaction type of odors previously, but we also started to get complaints about trash odors, and specifically from the Valverde community. And those are pretty much early morning complaints.
Right. But those just started even recently then?
I think that I only looked back towards April. We've periodically gotten trash odors, but this specific request to look back since the last hearing, it was on those 20 plus instances where the inspector had detected odors with complainants, and there were other odors too confirmed, but those were dates of specifically nuisance violations.
Okay. And the trash odors was coming from the working face area?
Correct,
Okay, and then going towards the Valverde community, you said.
correct.
Now, you mentioned that we got to try everything the last time, and one of them is the rescheduling of when the trucks can come into the landfill. And I think, I'm not sure, I don't think you mentioned the other previous landfill, but by name, maybe we'll avoid naming it. But in your opinion, you were also dealing with that issue at that time, correct?
Very much so, yes.
And how effective was it? And when did they start and when did they stop? And why did they stop?
Well, they stopped or ceased because the order for abatement had termed out, it had expired.
Right.
And we were not seeing any more nuisance violations of the caliber we were receiving at the time that before this was instituted. So we're going back a number of years. And the decision was made by that landfill with this board. I believe you were part of that too, that they would curtail and cease operating between 6 and 9 o'clock in the morning. And that was all refuse brought to the landfill. And so they were able to, what we noticed, and this went on for between 1 and 2 years, almost immediate drop in odor complaints, especially those in the morning hours that were impacting a elementary school. So we noticed the drop, and we thought that was a very effective and seemed to work, among other things too. That's just one part of it.
But to your knowledge, they have not, it's not a continued activity, right? They've
No.
gone back to their regular hours.
They have returned to the regular hours, yes.
Has that, to your knowledge, made it worse, or are you're not getting any complaints?
I would ask that he not speak to any allegations of violations specifically
Sure, I'm
for
not
that,
talking
for
about
that.
violation,
Yeah,
just,
thank you.
yeah.
So are you asking the question that, are we still seeing issues now that that particular source has gone back to regular operating hours?
Yeah.
Well, in the wintertime, we did see quite a number of odor complaints that were occurring between the months of December through the spring. And winds directions have shifted in that area, so we haven't seen or verified any nuisance violations since April. But we're only in August right now, and that source has a history.
So let's go back to this Chiquita landfill for a moment. And have you reviewed the wind data in the daytime? And what, I think you mentioned the average is how many miles, 5 miles an hour or so?
Right. I reviewed the reports that the inspectors did when they actually went out and did their field measurements.
One of the condition of the order is for the landfill to actually have some wind data, collect wind data. Have they provided that to you to look and to graph? I'm trying to get an idea, if this was graphed, if it was somebody had analyzed it, what was the wind pattern, what's the direction, what time of the day, and correlated with the complaints received,
Yeah, the landfill does provide that, especially on requests, but I personally haven't been reviewing that. I've just been reviewing our complaint reports.
Now, was it safe to say during the early morning hours, by shifting the time, you're anticipating a reduction in complaints, but not really. Are you also saying the odors will decrease? The odors will, no matter what, if there are odors due to trash, it'll still be there, right? Unless you're saying at 10 o'clock or whatever time you're shifting it to, that the wind direction is changing. So I'm looking for some kind of hard data such as that.
Right. No, I understand. We're receiving odor complaints throughout the day. Our inspectors, once they verified a nuisance, 6 complaints, if it's done by 8 o'clock, they're no longer in the community. They've already verified the violation, and they do their upwind and downwind, and they leave. So if we're going to say, are we going to detect something at 10 o'clock? If we're getting complaints, and we have been getting complaints, not necessarily trash odors, the majority of complaints that we're getting are other odors.
Now, is the assumption, because at that time in the morning when people are getting ready to go to work, take their children to school and so forth, so they're out there and you have the community smelling the odors because they are active and they're, going about their daily activities, correct?
Correct.
And around later in the day, it's sort of settled, they are at work or wherever, and so there are less complaints because the public is not there to complain.
Oh, and I want to say that, just people go to work. So generally 6, 7, 8 o'clock, people are leaving for work or they're dropping their children off. Well, now that school is back in session, it wasn't for a few months. But yeah, there's no set pattern. We do get trash odors on occasion, and we get a lot of other types of odors too. And a lot of times the trend is, especially in the morning hours, maybe depending on the barometric pressure, and then afternoon, particularly later in the afternoon, and people are coming back or coming home, or the wind might have shifted more from this to the southwest to the northeast. So we will be getting some complaints from a different community. And then in the evening hours, up to midnight and beyond, we're getting complaints in quite a bit of numbers, actually.
So I'm trying to understand the odors, even let's say they bring in start at 10 and whatever is causing the trash odors will be there at 10 o'clock, correct? And then, so there's the mitigation is because then they're not, people are not calling in basically around that time, but the trash orders are still in the community, correct?
Well, I mean, I don't know if I can answer that.
And that's where I think the data helps, and not
Sure.
having the data to look at, for me, it's difficult. Now, let me ask you another question. And this is going back to the other landfill for a second. When that routing took place, what was did they have to, I mean, you cannot just shift routes, the truck routes and so forth, and delay them unless you get permission and so forth, correct? And does it cause traffic issues? Did you notice that at the other landfill?
Yes.
Okay. So when you made this recommendation, you're weighing those issues with the reduction in number of complaints. Is that what you're doing?
As far as the traffic, that's not something that I was directly involved with, but yeah, that's a fair enough question.
Okay. All right. Thank you. I have no further question. Thanks, Mr. Secretary.
Mr. Pearman.
So you reviewed the proposed modification conditions submitted by AQMD, Matt?
Yes.
It's true that the project is subject to authorities, rules, orders from EPA, to your knowledge,
Yes.
and Los Angeles County Department of Public Health as well,
Yes.
and Water Quality Control Board.
All of them, yes.
Are you confident that the proposed conditions by AQMD do not in any way contradict those other authorities governing the property?
So, Mr. Pearman, I don't know if he can answer that. That's more of a legal question. I would note that the current order for abatement has a provision in case of conflict that allows suspension of an order for abate condition if it is a conflict with some requirement of another agency, and that's currently in the abatement order.
I still want to answer the question if we can.
I don't know if I can answer that. There's a lot of requirements going on. Where the specific overlap is, I couldn't exactly tell you off the top.
All right. I want to confirm something you said Saturday, that there was this more recent leachate spill last Thursday, presumably, and your testing was the landfill did not notify AQMD in a timely fashion of that?
We were not notified, correct?
I'm looking at the proposed contested modifications document, And we'll see if you can answer. If not, we'll find another witness or your counsel. But there was talk about reducing the maximum working phase to no more than 50%. You familiar with that condition or conditions proposed?
Yes.
So I'm looking at the chart of proposed contested modifications, and I forget which exhibit number that is. Chart is 59, maybe?
Yeah, 59, yeah.
And I'm looking at new subparts to 42 on the first page. And item small Roman double I says, if a South Coast AQMD rule forward to a nuisance notice of violation is received, then they shall implement certain measures immediately. And item B includes limiting excavation work for face, reducing the area by at least 50%. Do you see that or familiar with that?
Yes.
So under this proposed condition, is there ever a pathway to restore the work phase to above 50%, presumably if the conditions that led to the notice violation are mitigated or satisfied? Or in other words, if they have one NOV, does that mean forever they're limited to 50% per your client's, the district proposed subpart to 42?
I think it was really just for that one day that the notice violation was determined. So for the next day, if they didn't get a notice of violation, that provision wouldn't be applicable.
All right. And then could you turn to page 4 of that exhibit, condition 75? And that says respondent shall reduce its maximum exposed daily working phase area to no more than 50% of its permitted daily maximum. So is that, this means the same thing as in proposed 42 small double IB about reducing the excavation work phase area by 50%? Or are we talking about two different things there?
Just to clarify, condition 42 is referring to excavation?
That's why I just asked the question of.
Okay, thank you.
So my question was again, are those referring to two different things?
Yes.
Okay. So explain the difference just so it's clear to me, sir.
So during the excavation, if the odors are specifically related to an excavation occurring where odors are confirmed in the community and a notice of violation is issued or nuisance, that would be for that previous condition. And 75 is a much more general condition.
Okay, so explain your thinking. Why does 75, which seems to be a blanket, reduce your maximum exposed daily working phase area to no more than 50%? That does not encompass excavation work phases apparently. And just explain why that's not covered or subsumed under 75.
Well, I would think that the excavation is not occurring every day. There is excavations that are occurring right now as we speak, specifically for a certain part of the reaction area. But prior to that, there was many periods of time where there were no excavations occurring. And so that's what my thinking was the focus on this.
Okay, and so determining an excavation work phase is pretty much easily understood by the parties as to what that means on a particular day.
Correct.
Now, in the proposal, I want to know whether or not regarding 75, which said reduce its maximum exposed daily working phase area to no more than 50% of its permitted daily maximum. In proposing that, did you consider the impact of that restriction, if you would, on the business operations of the landfill?
Yes.
And did you conclude that it would negatively impact its ability to accept landfill quantities versus the norm?
Well, the landfill operates from 4 a.m. till, I don't know, 4 p.m., 5 p.m. I don't think I can say that personally that limiting how much of that is going to curtail their daily acceptance of refuse. I think that just my experience with other landfills, some landfills receive most of their refuse during the morning hours, and in the afternoon, things are much more quiet, slowed down. I don't think I can say for sure how this particular landfill, whether they accept most of their refuse before 10 o'clock or after 10 o'clock or between certain hours of the day. So I don't know if I can answer that clearly.
Okay, my question was not about the 7 to 10 a.m. Non-acceptance. It was about the 50% workforce reduction.
Right.
So again, assuming that applied to this business, you made some analysis of its impact on their business operations, the ability to accept the normal quantities for the landfill. And did you make that analysis? And if so, what conclusion did you and the district reach in that regard?
I don't know if I can answer that myself.
Okay. Thank you. No further questions.
Ms. Verdugo Peralta.
Thank you. Following up on Mr. Pearman's question regarding that notification that, or actually the incident where they did not report back to the AQMD, do you know what the reasoning was for them not notifying the AQMD?
No, I do not.
Thank you.
All right. Mr. Balakapalani, yes, sir, the floor is yours.
Thank you. Just as a follow-up, Mr. Israel, on the existing order condition 43, and for trash orders specifically, it says to ensure trash orders remain controlled. There is a condition that says that if the respondent detects trash orders in any stops during order surveillance, then they have to reduce their working phase by 25% of that day for the remaining operating day. Correct?
Correct.
You're familiar with that, right? So there is already a condition that if they smell their own patrol smells it, then they have to take this action.
Correct.
And 25%. Okay. And you think that's not adequate?
We didn't think it was adequate enough.
Okay. So now you're saying, okay, period, 50%.
Well, we're getting thousands of complaints since April, so that should kind of speak for itself.
Yeah, except you're not able to provide, at least to me, the breakdown. Is it, the reaction orders is, I think it's overwhelmed the community for sure. From what I've heard.
I'm sorry? What?
The reaction, the orders from the reaction area, that has been the driver in the last year and a half almost, it seems like,
Correct.
so,
Correct.
okay. All right. Thank you. No further question.
Ms. Robertson, redirect.
I'll waive redirect in order to move it along. Thanks.
All right, Mr. Dejinski.
I don't have any recross for Mr. Israel. However, given the fact that Mr. Israel did testify to, I think, 3 categories of documents which have not been provided to either the hearing board or to Chiquita, specifically any complaint data, any data with respect to the underlying investigation reports for the NOVs that he testified occurred between April and the present, as well as sampling results that were taken during these odor nuisance investigations, Chiquita would move pursuant to hearing board Rule 9A for a subpoena of those particular documents.
That's untimely at this point under the hearing board rules. That information was not requested and it's not received by the district until this morning. Under the hearing board rules, the district is entitled to 2 working days notice before the party may move for a subpoena. And we have not had an opportunity to respond to that. I will note, however, for the record, that Chiquita was on notice that these conditions would be at issue since July 26th. They did not request any such information of the district until August 19th, when the district was closed. It was received on August 20th, earlier this morning.
May I be heard briefly?
Absolutely.
We didn't know that this information was going to be required until Mr. Israel testified on Saturday, or exactly what the basis was going to be for the contested conditions, at least from the district's end. It seems fairly apparent that Hearing Board Member Balagapalan also believes that this information is important. I think that the comment that was made during our prior hearing was that the hearing board is being asked to take a drastic step. And without the necessary information in order to assess that, allow Chiquita to evaluate it, allow the hearing board to evaluate it, it just seems like that information is necessary.
I have to insist that this is completely improper under the hearing board rules. Under the hearing board rules, in order to issue a subpoena, a party must submit a proposed form of subpoena and a declaration under penalty of perjury that establishes the following findings in order for the hearing board to make. That is inappropriate at this time, not only because of the untimely notice, but because this is an oral motion. They have not complied substantively with the hearing board rules, and it is not appropriate for the board to rule on that at this time. Respectfully, the district maintains that you should enable the district to have those 2 working days of actual notice to respond to that request, because that's consistent with the hearing board rules and it may obviate the need for a subpoena.
Mr. Dudzinski.
We do have a declaration and a form subpoena that we'd be willing to lodge at this point in time. Also, while the hearing board rules do put some limits around the timing, Health and Safety Code Section 40840 does not put any such limits on the hearing board when it determines that it needs either persons or information in the analysis of any matter that comes before it. And so it is perfectly well within the hearing board's power to issue that subpoena today.
Mr. Pierman.
So, Mr. Gensi, are you saying that in his testimony, he relied on these documents that are not currently in the record?
That's correct.
Okay, and so are you moving to strike his testimony regarding those items if they're not produced?
Sure.
Well, I mean, you tell me.
That's not the motion. We think that the data is necessary to evaluate it. If they don't provide it, I think we would consider a motion to strike later, but I don't think it's necessary at this point in time.
Yeah, I mean, if it's important to their case and they didn't provide the documents, then that's a weakness on their part, right?
If I may be heard on that, specifically when a district inspector testifies, that testimony itself is evidence. Even if the testimony is based on additional data and analysis that the witness conducts or reviews, it is sufficient to make findings based on sworn testimony that is itself evidence. And what you have is Inspector Israel has come in person and provided sworn testimony. It is not necessary to make the findings that all of those underlying data and reports be submitted. And in fact, that's quite uncommon. You normally do not review every notice of violation report. Here, that is a cumulus amount. That is more than 200 different notice of violation reports, more than 30,000 total complaints. It is quite unusual, one, to request that information on no notice from the district. It would take us time to compile and properly redact that information. But it's also overly burdensome and to produce all of that to the hearing board to have to review that. In fact, it is more concise to have a witness like Inspector Israel, who has reviewed all of that data and can summarize and testify to their substance. And that is what the district has done here. Again, we would reiterate that a subpoena at this time is not proper under the hearing board rules. The district should be afforded the rules time to be able to properly respond to that.
So let me throw out a hypothetical. We do the subpoena, we go through the motions and this iterative exercise. We're going to come back next Tuesday, the 27th. So would that be ample time in order to provide all the substantive documentation, in addition, upload it for the public's review pursuant to the Brown Act, et cetera, et cetera, et cetera. I'm just simply trying to move us along, and I want us to try to find a happy median. I get both points, and I respect both positions. However, I think that it would be somewhat of an act of futility to subpoena documents that are already going to be forthcoming. We've just agreed to meet next Tuesday.
So if I can briefly respond, the hearing board rules contemplate at a minimum of 10 days, and respectfully, if a subpoena were to issue, the district would be coming back to this board with a motion to extend that time. 10 days notice is just unreasonable given the volume of data. And each of those things need to be individually redacted because they refer to the personally identifying information of members of the public. So it is not realistic that certainly I could not do it by next Tuesday. But truthfully, the district anticipates at this time that it would likely take more than even the 10 days contemplated by the rules.
So since we're having a hypothetical discussion and she just provided her perspective to my hypothetical, can we find a happy medium? Because I just don't want to have to then have a hearing on that motion, come back, and then we're dragging this out. And we do want to try to get to a happy median or resolution within a timely manner.
The district does agree, and if we were afforded the 2 working days, we would try to work this out with the respondent, not at a hearing.
Mr. Dujinski,
Uh,
Ms. Morgan?
My only discussion on the happy medium would be that we really only need, and it seems like what the thrust of Mr. Israel's testimony was with respect to the inspection reports. Those are only, I think, 20 to 24 NOVs. It doesn't seem like that's a great volume of data. And so if we would limit it to that, it seems like that would likely be doable.
Ms. Roberts?
I think that's possible. I would need to go back and check with staff. In addition to the 20, I don't know how many complaints that is total. But yes, that would reduce the volume. We agree.
So, Mr. Dujinski, can I just hold this decision in advance? We're here all day. If she can confer, we come back and then we can potentially make a ruling. But again, I want to move us along. I want to make sure that we don't impact the public any further. And we have vacations scheduled for certain folks on both sides. And we do want to be respectful of that, but we don't want to have to come back and entertain a hearing on a motion to do something that's already forthcoming. Mr. Balakapalan.
Yeah, if I may add, as you heard, I was here for the other case we were talking about. What they did present was not all the data, but the summary of the data. They actually presented a chart which showed, the time of the day, the complaints, the wind direction, things were to go. You seen that. So that was the basis that was then justified. At least that was the basis that to change the hours of operation, because clearly there was data indicating that. So we don't need all the underlying data. I'm sure you have to go through that, but there was actually, if you go back to the previous, I think it's 2017 or 2018, they actually provided a graph with the timeline and the number of complaints and the wind direction and so forth. And then they also had another one that showed, as a result of the changing hours, this hasn't occurred, whether the complaints will still remain as such or not. So that a summary data is all I'm looking for. I'm not, but I realize it'll take time to generate that, and I think it might take, I don't know how long.
All right, so I want to read this because I want to make sure we're bringing everybody along, the people on Zoom. The attorneys referenced Rule 9, which is discovery and evidence. And I'll just read a couple of the items. A1, the chair of the hearing board may issue subpoenas at the request of any party for attendance of witnesses at the hearing, and then it goes on, documents, et cetera, down below. But there's a word in particular, may. And it's not a mandate. And I don't want to have to do this, another part of this process. If there's opposing sides and we have to schedule a hearing on that matter in order to entertain another hearing for another hearing down the line, it just becomes a bureaucratic dance. And I'd rather we move this process expeditiously. So we'll hold the decision in advance, as previously stated. We'll come back toward the end of the day when Ms. Roberts has had an opportunity to confer, and then we'll render a decision moving forward. Since Mr. Dujinski has stated, I'm willing to take fewer documents, we're going to reduce the scope of the request, then there may be an opportunity. But again, any documents that are going to be provided to any of us will also need to be provided to the public. And so that may be a sore spot of contention with respect to redacting certain key elements. So again, I'm going to hold this and then we're going to proceed forward with the hearing.
To clarify, any documents that the district would produce would be redacted even to Chiquita Canyon.
No, and that's very clear. I think we understand the redaction. My concern is I want to make sure that the public is also privy to any documents that are made available and that the public has an opportunity to review at their leisure. Just want to make it clear because there are people listening, and this is a very enigmatic process to follow. I want to make sure people are bringing everybody along. I told people we would do that Saturday, and I want to maintain that throughout this process. All right, any more questions or comments from members of the board? Okay. Dujinski, think you have the floor? No, okay, Ms. Roberts.
Thank you. The district will call its second witness, Dr. Andrea Polidori, who is appearing remotely today. Dr. Polidori, can I have you state and spell your name for the record, please?
Sure. First name Andrea, Andrea. Last name Polidori, Polidori. My position is Assistant Deputy Executive Officer for the Monitoring and Analysis Division at the South Coast AQMD.
Can we ask a little bit low? Any way we can get the volume up, sir?
Doc, any way to move closer to the microphone, my friend?
I will surely try. What about now?
Okay, you might have to just speak up. Kevin, can we turn the volume up a little bit more? Okay, can we do testing, Doc?
Hello, hello.
Okay,
1, 2, 3.
I think it dropped lower. Okay, let's do testing one more time, Doc.
1, 2, 3. 1, 2, 3.
Are we good, folks? What that means is everybody's going to have to be quiet. If everybody's silent, then we'll be able to hear the doc. All right, sir, the floor is yours, Ms. Roberts.
Thank you. Dr. Polidori, can you confirm that you took the oath this morning?
Yes, I did.
And you mentioned your title with the South Coast AQMD as a Deputy Executive Officer for the Monitoring and Analysis Division. Is that correct?
Assistant Deputy Executive Officer.
Sorry, thank you for that correction. And in your role with Chiquita Canyon, in your role with the South Coast AQMD, are you familiar with Chiquita Canyon landfill?
Yes, I'm very familiar with this order of abatement, with Chiquita Canyon, all of the monitoring provisions, including in the order of abatement, more in general, with all air monitoring activities that have been conducted and are being conducted at and near the Chiquita Canyon landfill.
And you've testified in this case previously, isn't that correct?
I did.
If I recall, last time you testified, you were discussing a condition that would impose certain monitors be installed within the affected community. Is that right?
That's correct.
Have those monitors actually been installed to your knowledge?
Yes. So there's two, they're called micro GC monitors. They measure the concentration of several volatile organic compounds, including benzene. And one of them has been installed.
Doc.
Yeah.
We have a little challenge. We have a court reporter, and she's trying her best to capture each of your words. So perhaps if you would mind slowing down and trying to speak up, use your old school playground voice.
Very good. Thanks for letting me know. I'll try to go a little slower. So there's two instruments called micro GCs. What they do, they measure the concentration of volatile organic compounds, including benzene. And one of these instruments has been installed in the Valverde area at a monitoring station called MS Monitoring Station 12. This is northwest of the landfill, fairly close to the landfill. And the second micro GC has been installed at a different monitoring station northeast of the landfill in the Castaic area, farther away from the landfill at the monitoring station called MS-10.
So Dr. Polidori, I'm going to stop you. I think did you prepare an exhibit for today's hearing that would help us kind of walk through those?
I surely did.
Yes, I'm going to pull up, this is District Exhibit 60. Let me know if you're able to see that on the screen.
Yes, I can see it.
Great. So you were kind of talking us through where these two monitors are located. First of all, can I ask you to tell me, remind us, I think we've seen maybe a version of this map before, but can you remind us what is this map depicting?
So this is depicting the Chiquita Canyon landfill air monitoring network, which is operated and maintained by one of their contractors, SCS engineers. And, as part of the network, they have 5 what we call fence line air monitoring stations, MS1 through MS1 through MS5, depicted here by the red stars. And they also have 7 community air monitoring sites, MS6 through MS12, which here they are depicted by the blue pins.
And if I recall correctly, the condition that you testified to previously was about installing sort of different monitors than what's already in the community, but at 2 of the locations where there are already monitors. Is that right?
That is correct. So,
Sorry, go ahead.
no problem. For reference, since late 2022, Chiquita has been operating monitors for the measurements of methane, hydrogen sulfide, and winds at all of these stations. So as part of our OA conditions, we asked them to deploy 2 additional monitors for the measurements of volatile organic compounds, including benzene. One of these monitors at MS12, so in the Valverde area, and one at MS10 in the Castaic area.
And have you reviewed, you mentioned that these were installed since our last hearing. Have you reviewed any data that has come out of these monitors?
Yes, myself and my staff, we have reviewed all of the air monitoring data that have been collected at these 12 stations.
And I think you prepared a couple of additional slides based on some of the data that we've collected either from these monitors or monitoring that the South Coast AQMD has independently done. Is that right?
That is correct.
So I'm going to kind of ask you to walk through. This one is labeled continuous 1-hour average methane data. Can you walk us through what we're seeing on this graph?
Absolutely. So this is what we call a time series of continuous methane concentrations measured at all of the community air monitoring stations. Again, depicted by the blue pins in the map, also here reported on the top right. These data are, since the beginning of 2024. So, a couple of notes here. The landfill gas is typically made of about 50% methane, the rest being comprised by 45 or so percent of CO2, trace amount of H2S and other gases. So methane is a very good surrogate for landfill emissions. So as you can tell from the chart, this is, again, maybe take a look at it qualitatively. It seems that there has been no noticeable decrease in methane levels in the community surrounding the landfill in 2024. So this is important because it suggests that landfill emissions have not decreased much during 2024, have remained fairly constant over time.
And Dr. Polidori, you said methane is a good surrogate. And I understand, it's a high volume amount in landfill gas, but why wouldn't we use another high volume compound like carbon dioxide? Why is methane better as a surrogate?
Methane, is more relevant in terms of air pollutant, is a greenhouse gas, and also it's easier to monitor. There's several methods that allow us to monitor methane continuously. In this case, we have reported 1-hour levels of methane over time. So those are some of the reasons.
Okay. I'm going to go to the next slide, which is labeled as continuous 1-hour average of hydrogen sulfide data. Can you walk us through what we're looking at in this graph?
Sure. This is also a time series of continuous hydrogen sulfide concentrations measured at all community monitoring sites, again, represented by the blue pins in the map. These are about like 6 months worth of data. The dotted, something important to note, is that the dotted horizontal red line represents what is called the acute reference exposure level, or REL, for hydrogen sulfide, as established by the California Office of Environmental Health Hazard Assessment, or OHIA. So in the case of H2S, although it makes up less than 1% of landfill gas, it is a very significant contributor to landfill odors, even a concentration below those that are measured at the community monitoring site near the landfill and illustrated here in the graph. Also important here is that while the acute REL of 30 ppb has been exceeded only a few times since March of this year, there has been no noticeable decrease in H2S level in the communities surrounding the landfill. And this, is important because it supports the idea that odors emitted from the landfill can still have a significant impact on this community. This is also consistent with the fact that the number of odor complaints has not been going down in 2024.
Okay. I'm going to go to the next one, which is continuous 1 hour average of benzene data. And this is specifically at MS10 in Castaic. Can you walk us through what we're seeing in this graph?
Correct. So this is a similar format, and it's a time series of continuous benzene measurements measured at MS10, which is located at Live Oak Elementary in Castaic, again, northeast of the landfill. It reports data collected since the instrumentation was deployed in April 2024. Again, the dotted horizontal red line represents the acute REL for benzene established by OHIA. The 1 hour benzene concentration has been generally below 1 ppb part per billion, although we have observed occasional peaks as high as 2.5 to 3 ppb. However, important to note that all recorded 1 hour measurements are below the acute REL of 8 ppb.
So I believe you've testified previously about looking at benzene specifically, and I think you referred to, we would compare it to sort of basic background levels of what we would expect in the community. Can you remind us, how did South Coast AQMD determined, how do we decide what is a background level for the community?
Sure. So the background level for that particular area is based on measurements that we took at in the Burbank area back during our MATES 5 study. MATES 5 is one of our staple air toxic study that we have been conducted since the mid 80s. And so during the MATES 5 study back in several years ago, the average concentration of benzene away from, still in close proximity of this area, but away from the impact from landfill emission, was about 0.22 part per billion. So that's our reference point to establish what background level is in this particular area, so that we can compare increases in benzene level to what we believe to be normal, essentially.
And I believe you testified to this previously, but in addition to looking at the acute REL that you have here depicted on the graph, for acute toxics, for things like benzene, we would also want to monitor, is it above our expected background? Is that right?
That's correct.
Okay. And can I have you walk through our second graph? This is continuous 1 hour average of benzene data at MS12.
Yes, so it's very similar type of graph, time series of continuous benzene concentration. This time, measured at MS12, which is in Valverde, northwest of the landfill, much closer to the landfill. Also depicts data since April, mid-April 2024. Also in this case, you can see the dotted red line, which is the 1 hour REL for benzene at 8 ppb. Very similar to what we have seen before. The 1 hour benzene concentration have been generally below 1 ppb, although we have observed occasional peaks as high as 4 to 4.5 ppb, part per million. Also in this case, the 1 hour measurements were all below the REL for benzene of 8 ppb.
So, and again, and although they are below the acute REL, so the health threshold that we're looking for acute, would we say based on the data that we have that we've seen benzene above background levels for this area?
I would say that it's slightly above background level. So when, it depends also on the time period considered, right? Over the 1 hour, we can have, steep increase in benzene concentration. If we determine and calculate the daily average of benzene, the concentration can be slightly above background concentration for that area.
Okay. And I'm going to have you walk through our next slide. This is titled Integrated 24-Hour Average Benzene Data. Can you walk us through this slide?
Yes. And so this, again, time series, this time of, we call it integrated benzene concentration. So these are not 1 hour averages, but they are 24-hour averages. The method for collecting and analyzing the sample, the method for determining this concentration is different from before. So this refers to a different time period. So 24-hour average benzene data at all community sites. And so you can see here that while most values are close to background levels, close to zero, the daily benzene levels at two specific community air monitoring sites, MS6 and MS9, were often close or above the 1 ppb thresholds. Note that these two sites, we do not have, or rather, Chiquita has not installed a continuous instrument yet, so we don't know what the corresponding 1 hour concentrations are. So, but overall, this suggests that the concentration of benzene may have been significantly higher than 1 ppb over a shorter time period. And it should be specified here that Chiquita's contractor is in the process of installing continuous instruments for benzene measurements and other VOCs at these two locations and other community sites. And this will help us to better characterize the diurnal variation of these compounds.
And so you mentioned that Chiquita is in the process of installing additional monitors. To your knowledge, has the US EPA required installation of additional types of these same monitors, these micro GCs, at others community stations?
Yes, they have. So US EPA requires the deployment of 8 additional micro GC instruments for VOC and benzene measurements, 4 at fence line locations, so 4 at the red star that you see in the map, and 4 more at the community sites, the blue pins that you see spread out throughout the map there.
Okay. And I know because some of the data right now is we're looking specifically at monitoring data at monitors that Chiquita Canyon has installed. Has South Coast AQMD, you or anyone on your staff, been involved in reviewing their maintenance or calibration records for how they maintain these monitors?
Yes, we have. So I would like to say that our role, the Monitoring and Analysis Division and the South Coast AQMD, we do have, essentially an oversight role. So we don't conduct the measurements, but we make sure that all of these instrumentation are running properly, all of the measurements are as reliable and accurate as possible. So my staff has conducted measurements in the field, monitoring surveys using a mobile platform and mobile monitors. We have also conducted what they are called co-located measurement, specifically at MS6. We have deployed our own instrumentation alongside Chiquita's instrumentation, pretty much collected the same concentration of pollutants during the same time period, compared the results. And based on these comparison and also based on discussing and talking to the field personnel, we have helped them to come up with recommendation. We have provided recommendation for improving their standard operating procedure for using and pretty much all of their instrumentation. We helped them to come up with improved quality assurance and quality control measures to improve the quality of their data, and several other recommendations that they have taken into account. And as a result, it's my belief that the overall reliability of the data that they are now producing has been much improved.
So that gives us a good kind of overview of the monitoring data. I want to zoom in a little bit. And are you aware that there was a spike of air pollutant compounds recorded at the community monitors in early June 2024?
Yes, I am.
Can you give us just some context of what were the readings on that date, and what were the compounds that we were concerned with? I'm going to
Sure.
turn to your next page because we're going to break this down slowly, this graph, I think.
Yeah, no problem. So this is a pretty busy graph, but I'll try to highlight some of the main feature. So, I mean, in essence, we saw that at the monitoring station 12, again in Valverde, and close to the landfill, we noticed that on June 5th, essentially in the morning, there was a decrease in the total flow, in the total flare flow. So ideally, when flare is operating, in ideal conditions, the flow rate is fairly constant, right? But when there is a decrease in the flare flow rate, that is an indication that this particular gas collection control equipment is not working as it should, and that there might be several reasons. Could be a planned or unplanned operation of some of this equipment, could be maintenance, there could be many reasons. But in this particular case, early in the morning, when there was a decrease in total flare flow, soon after, we saw an increase, a jump in the total VOC concentration at the MS12 station. And this corresponded when the wind was unfavorable. So when the wind was blowing towards the station and the flare wasn't operating in ideal condition, there was an increase in total VOCs. Later during this day, and I think it's important to note this too, we also note another decrease in flare flow. This was, I believe, at about 2 p.m. But at this time, there was no corresponding increase in VOCs. And this was the main reason we believe, is because at this other point in time in the afternoon, the wind was not blowing towards the station. So all of this is to say that when landfill gas collection and control equipment is not operating in an ideal condition, there is more production of landfill gas. And when the wind is blowing in the community potentially might be exposed to higher concentration of landfill gas.
So I want to thank you for that explanation. I want to kind of break that down into pieces. So the first thing we notice is there's a decrease in the total flare flow, the flow of gas being pulled by the landfill for combustion. Is that right?
That's correct.
And the second thing we notice is that shortly thereafter, in the community at this MS12 station in Valverde, we saw an increase in target VOCs. Is that correct?
That's also correct.
And I think you put kind of in the inset of this graph a little windrose for us. Is that correct?
That's also correct.
So can you, just for those of us who are not familiar with reading a windrose, can you briefly explain what does that indicate the winds were at the time that's indicated between 7 and 9 a.m.?
Yes. So during that particular time period, the wind was mainly blowing from the southeast. So the way that you read a windrows like the one in this particular figure is that basically the point of the triangle tells you where the wind is blowing from. So in this particular case, the most of the wind was blowing from the southeast to the northwest in the direction of MS-12.
Okay, so the direction of the wind was roughly from the landfill to MS-12.
That is correct.
And so is it fair to say that this leads us to at least an inference that when they combust less landfill gas, if a flare flow, if that total flow decreases, that could create a spike of emissions in the community?
There's definitely, it could be the case for sure.
But then you also mentioned there was a second decrease in the total flow in the afternoon, and we didn't see a corresponding increase in emissions, right?
That is correct.
Is it fair to say from that that there might be a second inference that the wind conditions are particularly important in terms of whether and what emissions get into the community?
That is also correct.
Okay. So is this data that we've been looking at on this particular incident, is this something that you or your staff had a conversation about with anyone at Chiquita or any of their consultants?
Yes, we did have a conversation with their contractor about it.
Was it the contractor that you discussed with? Was that the person who actually informed you of the potential correlation between a decrease in flow at the landfill and an increase of emissions in the community?
That is correct.
Okay. So based on this, the discussions you had with that contractor, and they kind of came to you and your staff about, hey, this seems like a good correlation to see increases in emissions. Did you help draft and propose one of the stipulated conditions we have? This is condition number 83 regarding a study of this potential correlation.
Yes, that's correct.
Can you walk us through, just in general terms, what would that study actually look at?
So in essence, we would like, for the contractor to conduct a similar type of, what you see in this particular graph is an association, right? It doesn't really demonstrate a correlation. It's just based on one day. But what we would like the contractor to do is to come up with a study that that is try to accomplish the same type of, try to see the correlation between flow rate and total VOC concentration, but for a more extended time period from June 1st through December 31st. This is a lot of information, is a lot of data that the contractor in Chiquita already has access to. And it would be, they're a lot more familiar also with the operation of the control equipment. And we are aware that, they basically have a system where they can see this type of correlation in a much more efficient way, just because they have access to a data platform that allow them to graph this data in a way that is easier to correlate and understand. So in essence, we would like them to conduct a study to demonstrate whether or not there's correlation between a decrease in efficiency of the control devices and an increase in total VOC concentration when the wind is blowing towards the community.
Okay, and there's two other sort of related conditions to this. Condition number 81 and condition number 82, those require Chiquita to establish systems that would provide for community notifications and AQMD notifications, respectively, if there is such downtime of landfill gas equipment. Is that right?
That's correct.
So, in your opinion, given that you acknowledge that we still need to further study this, and that's what we're going to do in condition 83, Why is it warranted to have notifications at this time, even if we don't fully know the full extent of this correlation between the flare equipment going down or loss of flow and emissions into the community?
Yeah, we want to be conservative. We want to make sure that the community is protected. And, total VOCs, I only showed, one chart here, just, I mean, as you can tell, it's very busy already. So, but, benzene is also part of total VOCs. So we have reason to believe that when there is an increase in total VOC concentration, that might also result in an increase of benzene and other air toxic pollutants. So I think, in the interest of the community, it would be, to our and especially their best interest to have a notification system that, already can notify us, can notify the landfill, and can notify the community, when there might be this type of issues.
Thank you. Those are all my questions for Dr. Polidori.
Thank you, Mr. Dudzinski on cross.
Thank you. And thank you for being here, Dr. Polidori. I only have a few brief questions. Were you able to hear Mr. Israel's testimony from this past Saturday, August 17th?
I was, yes.
Do you recall him mentioning some air samples that were taken during odor nuisance investigations by South Coast AQMD inspectors?
Yes, I think that was mentioned in a couple of situations, so it depends from the context, but generally speaking, yes.
And would it be you or somebody in your division that would review sampling results from that type of sampling effort?
It would be somebody from our group, from the monitoring analysis group.
And do you happen to recall reviewing any results from any such samples taken during an odor nuisance investigation of Chiquita?
Not lately, honestly, because I mean, it takes also time to basically analyze the sample, come up with the results, and then eventually end up with conclusions. But I do not have, like, on the top. I would need to go back and take a look. On the top of my head, I don't remember, those results.
So nothing that like stood out to you that you would recall?
That's correct.
Okay, no further questions. Thank you.
Mr. Balakapalan? No?
Yes, I
Okay, there we go. All right. He's the senior member. He has more seniority than anybody. He goes first.
Morning, Mr. Polidori.
Good morning.
Have you reviewed the ROUX? I'm not sure if I'm pronouncing it right, ROUX report?
I have, yeah.
Yeah.
That is from 2023, so quite a long time
Yeah,
ago.
it was part of the Appendix K that was given to the board,
Sure.
And when I look at the charts that Ms. Roberts walked you through, and let me take the one for I'll skip methane. I'll take H2S, which showed the 30 ppm acute REL. Now, the
Yes.
ROUX report also looked at the chronic REL, which is much lower. Why is there no reference to the chronic REL? Because the data shows I think it's about 8 ppm, and there's a exceedance of that all throughout the period.
Yeah, I mean, that is a good question, but the chronic REL is basically established for lifetime exposure. So, I mean, it depends, right? I think it's all about context. Usually, when we measure 1 hour concentrations of a pollutant that has an REL, we tend to report the 1 hour REL because that is more kind of an apple-to-apple correlation. However, if one had to assume that the community has been exposed to that type of concentration over a much, much longer time period, then a comparison to the chronic would make a little more sense. Although, I mean, again, the chronic REL is over a lifetime exposure.
Lifetime, but there's an 8-hour average standard also, correct?
Yes and no. So for I don't think that H2S is an 8-hour REL. And, lately I've been working quite closely with the EOHIA staff. I've been part of the incident response team. And so the 8-hour REL is basically for, it's a worker exposure type of REL. So in essence, described simply, an 8-hour REL is worker exposure for workers that are basically working right outside the source of interest. So that would only refer to a situation where there might be some worker exposure for people working right outside the landfill, which is not the case. So we tend not to consider the 8-hour REL as a reference.
I'm going to read a paragraph from the community report, the Rooks report, page 29. It says community ambient air level for H2S over the last couple of years has periodically exceeded the California CAAQS and OHIA acute 1 hour REL of H2S for 0.03 ppm and OHIA chronic REL of 0.007 ppm for H2S, and the frequency and intensity of these exceedances increased in 2023. That's what this report is stated.
Yep.
So you don't think there was a need to also track the chronic REL?
A couple of observations there. You might remember that during my previous testimony in early 2024, we showed H2S concentration in 2023. And at that point in time, the concentration of H2S were much higher. I believe that we showed concentration in exceedance of 250 or 300 ppb, right? So it was a different situation back then. To the best of our knowledge, the concentration of H2S have decreased a little, but they're still high enough to pose a concern in terms of odors. When it comes to, any, interpretation of RELs, my expertise is in air monitoring. I'm not a health expert. So, I can tell you why we chart and why we graph things in a certain way, but then I wouldn't feel comfortable kind of extrapolating that to assert, potential health impacts on the community. That said, again, it's all about context of what we would like to show in the graph. When we are showing 1 hour concentration of a pollutant that has an REL, we tend to report the corresponding 1 hour REL.
Okay, I'll save my question for the health effects officer or whoever comes before that. I understand your expertise is in the air monitoring, the data, and not the health impacts. But I question why the REL line for a chronic was not also included. And it's the same for not only H2S but also for benzene.
Yeah, and I mean, again, I think for the benefit of the hearing board, the chronic REL for H2S is 7 ppb as a reference. I think it's a little less. They reported in microgram per cubic meter. In ppb is about 6.7 or 7, around that. For benzene, the chronic REL is 1 ppb. So as you have heard during my testimony, I've referenced the 1 ppb quite often, right? So although we didn't specifically put that line on the graph, the 1 ppb benzene level is what we reference when we are trying to interpret those results. So, yeah.
Okay. Okay, no further questions. Thank you, Mr. Polidori.
No problem.
Any additional questions? All right, Ms. Robertson, redirect.
No redirect.
Okay, good deal. Are you have any additional?
Yes, we will have one more witness.
Very well.
You want to take a break, sir?
You know what, you're right. Why don't we go ahead and take what do you say, 10?
15-minute break.
Okay, 15-minute break. We'll come back. Just a minute, we'll come back at 11:15.
Thank you.
Thank you, Kevin. It's Kevin, we're gonna go back on the record. It's 11:18 a.m. and we're back on the record. I believe Ms. Roberts, you at the floor?
Yes,
calling
we
another
have
witness.
one further witness. The district will call Nathaniel Dickl. Mr. Dickl, could you state and spell your name for the record, please?
Yes, Nathaniel Dickl, Nathaniel Dickkel.
And can you confirm if you took the oath this morning?
Yes, I did.
And can you tell us what's your position with the South Coast AQMD?
I'm a senior air quality engineer in the toxics waste management team.
And how long have you been in that position?
I've been in that position approximately 2 years, 7 total years at the district.
Okay. And in your role with the South Coast AQMD, are you familiar with the Chiquita Canyon landfill?
Yes,
Are you familiar with the order for abatement in this issue?
yes,
So I think you were with us on Saturday and you heard all of the prior testimony from that prior day.
yes,
And I think you may have heard in my opening, I mentioned that there were several kind of high-level engineering solutions proposed to the ongoing landfill reaction in my opening statement. Is that right?
yes.
And I want to walk through a couple of those kind of high-level engineering solution to odors. One of those was a geosynthetic cover. Is that correct?
Correct.
Could you remind us what is that and why is it a solution to odors potentially?
So the geosynthetic cover is, I believe, a 30 mil cover that's being placed over the reaction area. So its intent is to essentially, I guess, trap the gas from the reaction area from being released through the surface of the landfill. So that cover will keep it there, and then they'll have a gas collection system under the cover to collect that gas.
And so ultimately, when you have a gas collection system, that gas collected would be routed essentially to the flares or other combustion devices on site.
Correct.
Okay. So if this geosynthetic cover is not put under seal, if it doesn't have that gas collection device yet, would it be possible for emissions to escape even though there is technically the 30 mil cover?
Yes, if the cover isn't sealed or if the collection equipment under it isn't extracting properly, then there's going to be emissions that basically escape from the weak points, which could be the edges, or if there's any rips or tears in the cover, or I guess areas around wells if it's not sealed sufficiently.
And do you know what was the original proposed timeline for us to have this geosynthetic cover over the reaction area completed?
It was, from my memory, proposed to be completed in April of 2024. I think that was for the West Slope area.
And do you know what the current proposed timeline for completion of this geosynthetic cover is?
I think it was recently extended under the LEA or EPA to October sometime.
Okay. So another of the kind of high-level engineering solutions that we were discussing for specifically the reaction area was to limit surface emissions. Is that right?
Correct.
And as part of this abatement order, Chiquita has been required to kind of conduct assessments to see what kind of surface emissions we're seeing at the landfill generally, but also the reaction area specifically.
Yes.
Can you explain to us what are those studies that they have been doing?
So they've been doing flux chamber studies, which essentially it takes a chamber or various chambers, and they're placed at various locations, various grids on the landfill surface. They're placed there, and then essentially the surface emissions go up into the chamber. They do analysis of that gas and see what's in there, and I guess the mass of the constituents in there, and then they extrapolate that data over the entire landfill surface to essentially calculate surface emissions from the landfill.
Is it fair to say that these flux studies are essentially kind of a snapshot in time of what the landfill emissions look like?
Yeah, they're a snapshot in time, and there's only so many of those chambers on site, and they're extrapolating that data over the surface area of the landfill. So there is some uncertainty in the results.
So have they done more than one flux study that you're aware of so far at Chiquita Canyon landfill since this reaction started?
Yes, one, I think October 2023, and then a recent one under the order June 2024.
Did you review both of those reports?
Yes.
Were there differences in the data of results that we were seeing in terms of emissions that we were calculating out at the landfill between October of 2023 and the June of 2024?
Yeah, so it depends on which compound you're looking at, but essentially the results showed approximately 4 times more surface emissions in the June analysis compared to the October analysis.
Okay, what does Chiquita Canyon attribute that 4-time increase to in the June report?
So, like you mentioned, it's a snapshot in time. So during that test, there was a couple control equipment down. I think the thermal oxidizer on site and one of the flares. And then also they had mentioned some well liquid impaction issues. So those are gonna inhibit their ability to collect gas. So they stated those upset conditions. They aren't pulling gas to the control equipment. It's being released through the surface of the landfill. So they stated those emissions may be overestimated.
So in your experience, if, for example, you do have a flare or a thermal oxidizer or both go down during the pendencing of, while the study is being carried out, and or if you have wells that are impacted by liquids, are those rational results? Would we see the emissions go up by that much?
I wouldn't be able to say how much, but it does make sense engineering wise that if the control equipment is down, the surface emissions will increase.
So then, on the basis of that explanation, that at that time, the thermal oxidizer and a flare and maybe some of the wells were not acting as they should have been. They were, I think you called them upset conditions. Would South Coast AQMD then say the June results are not valid?
I wouldn't say that we think they're not valid. The data collected and the analysis performed is accurate to what was occurring at the time. There isn't like bad data that was collected. It's just, I guess, the extrapolation of that information to the landfill surface that's the uncertainty.
So is it fair to say that even if that isn't representative, like the June 2024 results might not be representative of all days, it's harder to extrapolate that to, for example, an entire year's worth of emissions?
Yes, correct.
But even so, even if there were upset conditions, the South Coast AQMD considers that this landfill sometimes has upset conditions, and those results should still be useful for determining what the emissions are.
Yes, so we do think during that time, those results did show like excess surface emissions, which then went on to likely impact the community nearby.
So I think you were also in the room this morning, and did you hear Dr. Polidori's testimony this morning?
Yes.
In your opinion, based on what we saw from the June 2024 flux study, that you had a flare or a thermal oxidizer essentially go down for a period of time, and that seemed to increase surface emissions. Does that seem to also lend support for what Dr. Polidori had discussed about if you have a decrease in flow rate, that might spike emissions in the community under certain circumstances?
Yeah, so essentially, yeah, the flux study shows what was mentioned by Dr. Polidori under that, I believe, condition 83. When the control equipment is down, then the surface emissions would increase and likely impact the community.
Objection. I'd move to strike the testimony about impacts to the community. He's not an expert qualified to talk about impacts to the community.
He's referring to, the question posed to him was whether the data of the flux study, which he is an expert at, he did testify that he reviewed, would support the study called for, as Dr. Polidori had testified. And he's essentially answering in the affirmative.
Yeah, the objection is sustained and is stricken from the record.
So given the potential that we've seen between these two flux studies that we've done so far, does that result, the 4 times different change in emission in the most recent flux study, would that support the need for continuing to conduct these flux studies?
Yes, so like I mentioned, each flux study has uncertainty and then it's also a snapshot in time. So if you do more flux studies, you'll have more data, more information of what's going on with the landfill surface. So you can get a better idea of, I guess, the health of the landfill and how the improvements are achieving or not achieving what they're intended to.
So you mentioned that Chiquita indicated as one of the possible upset conditions was impaction from wells. Did the order for abatement actually have conditions related to adding additional wells to the reaction area specifically?
Yes, it did.
And that's in condition 15, and we had some pretty specific modifications that the parties are proposing to 15B. Is that correct?
Yes.
Can you walk us briefly and just remind us, why did we propose expanding the number of wells to a specific level of density in the reaction area?
So that 15B, the density in the reaction area was essentially because they had a lack of wells in that area due to the high temperatures and pressures. A lot of their wells had failed. So we proposed a 3 well per acre density so that they essentially have enough wells in the area to extract the large volume of gas being generated.
And one of the sub provisions of 15B, I think it's little Romanet I, required Chiquita to meet sort of an initial milestone in that well density, and that was 50%. Is that correct?
Correct.
And what was their deadline to meet that 50% of that well density?
July 1st, 2024.
So as the way the current condition is written, did they meet that well density to the best of your knowledge?
Yes.
But the parties are stipulating to a clarification of 15B. And specifically, can I have you look at that first red line in 15B? This is Exhibit 57, page 7. And the red line says installed with desired depth within the landfill waste mass. Can you explain, why are we seeking that kind of clarification?
So essentially, from discussions with the landfill staff, in the reaction area, they're currently unable to drill to the desired depth. So in these 3 wells per acre that we originally imposed, they did not drill them to the desired depth, which is generally approximately 30 feet above the bottom liner of the landfill. So we added this clarification here to ensure that they do try and drill to that depth instead of drilling, I guess, for example, if the waste is like 300 feet deep, we would want them to drill the well 270 feet. But from what we've seen, and I can't speak for every well, but in general, it seems like they're only currently able to achieve about 140 feet in depth.
And can you explain why we would want that full depth in terms of imposing this as a mitigation measure for odors?
So the larger depth, the more surface area of the well, perforated surface area to collect gas. So each well would have a greater gas extraction capacity if it can be drilled to the depths within the reaction area. And then that reaction area is in the deeper waste of the landfill. So when they're only extracting the gas above the reaction area, it may not be achieving what we would want it to achieve in collecting all that gas.
So to the best of your knowledge, if we're looking and assessing wells that are this proper depth and the full depth that would be sufficient for the odor mitigation purpose of this condition, are they at 50% of that required density?
Not to my knowledge, no.
Okay. Can you explain, the parties I believe are proposing in that same condition, sort of alternative procedures for if they haven't met that 50%? Can you explain kind of walk us through what those alternative procedures are?
Yes, so these 15B and then triple I and after that. So the landfill isn't currently able to drill to the desired depth because of the pressure, temperature, and saturation in the reaction area. So they drill the wells, and then the boreholes collapse at a certain depth. So we understand that they can't drill to the desired depth currently. So this is alternative measures. So this gives them an extended timeline to drill at the desired depth, and then also these additional provisions, such as if any reading of 500 ppm VTOC is detected in surface monitoring, they take corrective actions, but if those don't work in the area, they're essentially going to be required to install an additional well to ensure they have adequate gas extraction in those specified areas to minimize surface emissions.
Is it fair to say then, given what we know, that they may not be at 50% of the desired density of wells that are at the proper depth? Is it fair to say that they're behind schedule for that larger odor mitigation of what condition 15B was supposed to achieve?
Objection. That's misstating what 15B currently says. 15B currently has a deadline that has nothing to do with the desired depth.
Ms.
I'll
Roberts?
restate the question.
Very well, very well.
If we are looking at 15B and imposing a requirement of a desired depth, which you said was for the purpose of ensuring odor mitigation, is that right?
Odor mitigation, and also, as the landfill has stated, extracting the gas and the liquids will reduce temperatures and could mitigate the reaction overall. So, yeah, collecting the gas, but also trying to mitigate the reaction as well.
So if condition 15B is adopted as stipulated currently by the parties, 15B2 still has a demarcation that says by July 1st, install 50% of wells necessary to achieve the well installation density, correct?
Yes.
If 15B is adopted as stipulated, to the best of your knowledge, would they be behind schedule?
Objection. That continues to misstate what is stipulated to by the parties. 15B3 specifically states that if the wells are incapable of being installed, which the witness already testified.
I'm not
is
asking
true,
if he's
we have
violating.
until August 17th, 2026.
I'm not
So you're
asking.
not behind schedule.
I'm not asking if it's in violation of the condition. I am asking if it's behind the schedule of July 2024 installation of 50% of wells necessary to achieve the well density would be obtained.
It's misstating what the schedule is based on the witness's own testimony.
The objection is sustained.
If condition 15B is adopted as written, do you agree that the parties would have to extend the deadline from what is currently in condition 15B in order to meet this mitigation?
Objection. Continues to misstate. The deadline is clear. It's August 17th, 2026, based on the witness's own testimony.
Not in the current condition. I'm asking if it is adopted as written, if the change that is addition to this condition were to be adopted, does that require an extension of the schedule from the currently written condition 15B?
It's misstating the entire premise of the condition. Why don't we just read the condition and ask him if 15B3 is on schedule?
Because that's not the purpose of the question. The question is the schedule needing to change based on the current status of what we know of the wells that have been drilled? And And the parties are proposing to extend the schedule in the stipulated modification of condition 15B.
Hold on one second, Mr. Pearman.
So that's my question. If you've stipulated to changing it, why do we need evidentiary discussion about the
Because
change?
there's still a standard of good cause, and we do still need to put in evidence to support why we're proposing a modification. If there's not evidence that they're behind schedule, then they would not need any modification whatsoever to this condition. The district will still insist the clarification, which meets the purpose of condition 15B, that all wells need to be drilled to a desired depth. If Chiquita is rescinding their stipulation as to extending the schedule because they don't consider it an extension, then that's a change in my understanding. But as proposed, the parties are proposing to extend the schedule. And it is a fair question to ask, do we need to extend the schedule?
May I briefly respond?
Hold on one second,
As
Ms.
far as I'm concerned, the parties have stipulated to it, and so we'll decide if there's good cause or not. So I don't see why we have to pursue it, but I'll yield to the chair.
Ms. Morgan.
Just my brief response, the Chiquita and the parties have stipulated to the language in 15B and the proposed modifications. We merely object to the misleading testimony.
The objection is hereby sustained.
So I'm going to take you to one of the contested conditions that we're discussing today. This is in exhibit number 59. Can I have you turn to page number 4 and specifically looking at condition number 66? Can you remind us what is the existing condition number 66? Generally speaking, what is that condition about?
So 66 was having the facility essentially, it provided a deadline for them to install and operate a real-time remote monitoring system to measure pressure and landfill gas at their wells. So I believe currently the landfill, well, yeah, they have to go out manually and have someone go check the pressures and temperatures. So we want that to be in the, I guess, operator control room.
So in your testimony so far today, we've discussed a couple of different issues with wells. Either maybe some of the wells are not drilled to the desired depth. Maybe some of the wells have had liquid impaction issues that contribute to emissions. Given those challenges, do we still consider this type of monitoring in the wells a necessary and appropriate condition?
Yes, so we believe having this information with the operators will allow them to better, I guess, optimize and tune their well field and just have more information on what's going on in their landfill real time.
And the condition as originally adopted required Chiquita to take this and evaluate it by their reaction committee and submit recommendations. Is that correct?
Yes.
Did they do that?
Yes.
And in that, did they indicate in that proposal that they sent there was recommendations? Did they indicate that the installation of the system couldn't be done by the deadline that was originally proposed in condition 66?
I do not recall seeing that, no.
So to your understanding, what are the challenges with installing this system that Chiquita has raised?
So they did mention a couple of challenges in that report, mainly on, so if they're measuring pressure and temperature, they'll require sensors. So I guess the composition of the gas and then the temperatures that they're encountering. So that was one of their prior concerns. But then we recently heard from them those items again, but then also physical compatibility with their pumps that are in the wells. So that's, I guess, the concerns that we've heard from them recently.
So in terms of compatibility with their specific wells, given your understanding of these types of systems generally, is this the sort of equipment that you would have expected Chiquita to have been able to purchase off the shelf?
Not necessarily off the shelf. I think each landfill would be unique, so they might have some custom design involved for installation.
So I'm gonna actually pull up this condition so we can kind of look at the requirements. And in the modifications, sorry, are you not able to see that on the screen? Are we able to pull up the screen share on the screen?
Yeah, Kevin, any way you can assist with that? We want to display exhibits.
On my Zoom, it says it is screen sharing.
Can you share the page or?
Yes, this is page 4 and 5 of exhibit 59. So you have that in front of you, Mr. Dickl?
Yeah, I have it.
Can you walk us through, starting with the red lines in conditions, proposed condition 66B, what is the information that South Coast is asking for in that condition?
So essentially, it reads submit all known information of design, implementation, installation, and specification issues or concerns. So we were informed recently of all these issues with liquid level monitors in the wells and compatibility with the pumps, and then physical compatibility concerns with the temperatures and gas composition. But we, I guess, don't have evidence of these things currently, so this is kind of just being added so that these items mentioned are provided to us so we can sufficiently see what the issues are.
Okay, so is it fair to say that condition 66B requires them to kind of give us all of the documents that would show us the design or engineering challenges that we're encountering with this proposed system?
Yes.
And then condition 66C goes on to actually require them to contact vendors or manufacturers to essentially resolve those engineering challenges.
Excuse me, Ms. Roberts, one second, Mr. Bella.
Yeah, just for clarification, because I have it, you said highlighted in red, but it's green.
Sorry, I mean red line as
red
in
line. Okay, no, okay, no.
all of the colored language. So just to clarify, green text is the district's proposed modifications. And then on the right-hand column, if there's blue text, that would be Chiquita's proposed changes.
And I apologize for the interruption.
Sorry.
No problem.
So for condition 66C, is it fair to say that after we get the information to what are all the engineering and design challenges, essentially go contact vendors or manufacturers to figure out how to solve those engineering or design challenges?
Yeah, that's the intent.
So am I correct in 66C, when we compare the language on the left-hand column, that's South Coast, versus the right-hand column, that's Chiquita's, really the only difference is the single word distributors?
Yes.
Why do we oppose contacting distributors in addition, as, you know, meeting this requirement to facilitate solutions?
So essentially, from what we've heard from the facility, it seems like it's more physical compatibility issues that are occurring. It's not like a technical or other kind of solution. It's like it requires a physical design change likely. So we would think a vendor or manufacturer would have that engineering expertise to design a system appropriately, as opposed to a distributor who may be more of on the sales side.
So is it fair to say that we think the challenges that might cause delay in implementing this system should be limited to engineering challenges or design challenges with the physical installation in Chiquita's specific wells, and less so on the sales side of which or who to procure this from on what time frame?
Yes.
Okay. Is that the same difference in subprovision D, which is at the bottom of page 5, going on to page 6? Essentially the same thing. We're seeking, you know, submit findings and solutions that were to A and C, you know, to the challenges you identified and the people, the engineers you work with to solve it, and submit those findings, is essentially the only difference between the parties still in subprovision D, that same distributor.
Yeah, it's the same issue.
Okay. And so provision 66E revises essentially the deadline for the install. Is that correct?
Yes, it does.
And on this condition, 66E, respondent has a bit more substantive, more than just adding the word distributors, has more detailed changes that they are requesting. Is that correct?
Yes.
And essentially, can you explain what is your understanding of what is respondent proposing in 66E?
So essentially, they're proposing to just do I guess, a pilot test with a few of the wells, and then provide a report and recommendations on that with an extended timeline of December. I guess that's their proposed subpart E.
And South Coast AQMD's proposal for provision E doesn't have any kind of pilot study. Is that right?
Correct.
Why do we think a pilot study is not necessary here?
So this condition was originally drafted requiring pressure and temperature by the indicated October deadline. So we didn't get into the details specifying like pilot tests or anything like that. We kind of imposed do this and you guys can figure out the engineering solutions, but we don't think we need to be, I guess, involved in a pilot test. Like we think it should have already happened or could happen without us imposing a condition on that. And I guess the main disagreement is we see their condition E as having that pilot test, which then extends the timeline, and then it's not even committing to installing that remote monitoring system.
So there is on respondent's side, it's labeled as F, a entire provision that's it. South Coast has an F, but they kind of pick up with South Coast revisions at subprovision G and add this new condition subprovision F. Is that right?
Yes.
And what is your understanding of what respondent is proposing in subprovision F?
Yeah, so I guess this is kind of what I mentioned. So it's an F instead of E, but it's submitting a report on the viability and functionality of the initial system and the usefulness. So, and that's with another extended timeline. So it essentially appears that this timeline is just getting extended far out from what we originally proposed. And it's adding reports that we don't think necessarily are needed. We want them to just work with the engineering design manufacturers to get the system installed.
And so your position is, even though we have this reaction committee, we don't need a second report on viability?
Correct.
Do you feel that the South Coast AQMD has already determined that this is viable based on, our own internal assessment coupled with the reaction committee's first proposed recommendations?
Yes, and one of the purposes of the pilot study is for liquid level monitors, which is not required under South Coast AQMD's proposed condition. It can be added. We think it would likely be useful, but our condition requires pressure and temperature monitoring. So extending this for the purpose of liquid level monitoring is, I guess, opposed to what South Coast AQMD intended.
So given your earlier testimony about we've seen some concerns with wells specifically, either them being going down and creating excess emissions, or in new wells that they're drilling not be able to get to sufficient depth, do we consider that this is a necessary condition on the time frame that South Coast AQMD is proposing?
Yes, so we'd like this to be installed relatively quickly, especially, I forget if it was added under the March or April OA.
Okay. And I think we heard from Inspector Israel on Saturday, and amidst his testimony, he agreed that in addition to the nuisance violations he was talking about, there were other violations that Chiquita had been cited for, including for installing and operating equipment without permits. Do you recall that?
Yes.
And can you give us just a general overview of what kind of permits and permit applications have been required under this OA to date?
So I'll just go through quickly a list. So condition 16 was a modification of the landfill gas collection system for additional wells. Condition 19 was a modification of the leachate collection and storage system for additional tanks. Condition 21 was new construction for flare 4. Condition 41 was a Rule 1150 excavation plan. Condition 57 was a modification again of the leachate collection and storage system for additional tanks. Condition 58 was for the thermal oxidizer operating on site. 59 was for a liquid leachate hazardous treatment system. Condition 60 was a modification of the landfill gas collection system for its tie-in to the leachate storage system with its vent lines. Conditions 61 and 62 were modifications of the flare systems for the combusting of the hazardous liquid vapors from the vapors from the hazardous liquid storage tanks. Condition 71 was for the surface gas collection system underneath the geosynthetic cover. And then condition 73 was for engines.
Okay. So is it fair to sum up that as there's a lot of new or modified equipments and processes happening at Chiquita Canyon landfill right now?
Yes.
Okay. So of those, to the best of your knowledge, has Chiquita Canyon complied with those kind of conditions that you just ticked through in terms of when they were supposed to submit applications to the South Coast AQMD?
Yes.
Have any of these applications that have gone to the South Coast AQMD permit engineer required additional requests for information from the engineer to Chiquita?
Yes, I believe nearly everyone or everyone has.
Okay, so are any of those permits completed that you ticked through and issued?
They're still open.
Okay. So some of those permit applications that you ticked through, they relate to actually increasing the combustion capacity at Chiquita Canyon. Is that right?
Yes.
Can you just give us a briefly an overview of what new or additional combustion capacity have we seen essentially since this abatement order started? Let's put the start there at September of 2023. What's been new or changed since then?
So since September 2023, they've installed Flare 3, rated at 6,000 standard cubic feet per minute, and a thermal oxidizer rated at 4,700 cubic feet per minute. They have lost the ability to send gas to Amoresco, Chiquita, which is about 4,000 SCFM.
So to the best of your knowledge, was Flare 3 that was that added because this reaction was ongoing?
That was added, I guess, as the general capacity increase for the landfill. It was submitted before any of this reaction issue was known. So it was a planned capacity increase.
Okay. To the best of your knowledge, was the thermal oxidizer added to increase capacity during the specific reaction?
Yes, that was as a result of the reaction.
Okay. So, and then you mentioned that there also has been a loss of capacity at the landfill gas to energy plant.
Yes.
So can you just give us a general sense of a net gain and loss over this time period of what we're looking at?
So in terms of the rated capacity, I guess they've gained 6,700 SCFM. So their total capacity, rated capacity is 18,700 SCFM currently.
Okay. And I've noticed that when you're answering these, you're saying rated capacity. Is there a difference between rated capacity and what they're actually pulling at the landfill, like what that equipment is actually used at?
Yeah, generally. So I think one item is the thermal oxidizer they have on site. So for several months, it looked like it only ran at about 400 SCFM, and then I believe the landfills tried to make improvements to it, but from the data we have, we don't necessarily see it having surpassed 1500 or so, maybe 1800 SCFM, even though it's rated at 4700.
Okay. Do we know in general sense of an estimate of what increase in gas generation there has been over this same time period, essentially since the reaction started?
Increase in gas generation is hard to define. So we have, so before the reaction, we have the 2021 and 2022 data for the gas collected, but gas collected doesn't equal the gas generated. There's more gas generated than what is collected, so it's hard to compare generation versus collection.
Okay. Do we think that based on what we know in your own experience, as well as the testimony you've heard at prior hearings in this matter, do you think that there's evidence to suggest that gas generation would be increasing given the ETLF conditions at the landfill?
Yes, so we've, I guess the reaction committee estimated an approximately 15% increase of gas from the reaction. So based on a recent landfill gas generation model, their current estimated generation is approximately 17,000 standard cubic feet per minute.
Okay. In to the best of that South Coast AQMD can estimate, do we think that in the immediate term, like the right now, that Chiquita Canyon has sufficient combustion capacity?
It's hard to answer. In terms of rated capacity, they could, I guess, technically, if operating fully, they could combust 17,000 SCFM, but I don't know if we would consider that to be sufficient capacity because if any unit is offline for any period of time, they would not have sufficient capacity, and downtime is to be expected.
And so essentially, we consider as part of the equation for sufficient capacity some level of like redundancy, such that if one flare might go down, you would have another flare be able to come online.
Correct.
Okay. So is that essentially, that goes to why we've had additional permit applications for additional capacity, but the parties are also proposing in the stipulated conditions to move up the permitting timeline for another flare, flare number 5, even though we're still in the permitting process for flare 4. Is that right?
Yes.
Do we think that flare 4 and ultimately flare 5 are going to be needed to address these reaction conditions ultimately?
Yes, so we had them do a study under condition 70 for that specifically, and yeah, they'll essentially need flare 4. They'll need flare 2, the thermal oxidizer, flare 3, flare 4, and one of flare 1 or flare 5 from today through, I guess, 2030 to have that redundancy.
Okay. And I know you said one of either flare 1 or flare 5. Has there been any plans at Chiquita in the past to actually retire flare number 1?
Yes, I don't know the current update to that. It was originally flare 1 was going to be replaced with flare 4, but I'm not sure. I think it had been mentioned in a meeting. I can't say for sure, but I think that they're planning to keep flare 1 kind of based on that generation study for redundancy.
Okay. So one of the other things that Inspector Israel had testified to on Saturday, he discussed some of his observations regarding leachate and leachate storage and treatment on site. Can you give us a brief overview, since your division sees the permit applications? Can you give us an overview of how leachate is being collected, treated, and shipped for disposal at the present time at Chiquita Canyon?
Yes, so leachate is collected like normal landfill, partially in the liners underneath. And then also they have the downwell pumps pumping out the leachate. So then it's conveyed to leachate storage tanks, which I think maybe about 200 collect the raw leachate. From there, they have a treatment system where they send it through filters to remove, I guess, the main initial solids, and then they send it to activated carbon to remove volatile compounds like benzene. From there, they send it back into the storage tanks they have on site. They do sampling and analysis of the liquid in the tanks to, I guess, categorize it if it's no longer hazardous waste, and then they send it to an appropriate facility for disposal.
And so, to your understanding, with the exception of the first of those that you discussed, the collecting it within the landfill waste mass, is most of that new and in response to the reaction?
Yeah, the downwell pumps were kind of partially to remove liquids and remove heat from the reaction, kind of as required under this OA. So I don't think they weren't installed before this reaction occurred.
And those processes and equipment, those are among the in process but not yet issued permit applications we have?
Yeah, the leachate storage tanks and treatment system, that's, yeah, still being processed.
Can I have you turn to exhibit number 59 and page 8 of that exhibit? Try again. Oh, maybe it's going to work this time. Okay. See if I can zoom that in. I'm looking specifically at condition number 86 on page 8 of that exhibit. Can you briefly explain what is condition 86 trying to get at in this contested condition?
So since the leachate treatment, leachate collection and storage systems, they're essentially on site operating without permits. So this is kind of designed as a temporary measure, similar to, I believe, condition 42 for landfill excavation. We are imposing some general requirements on the operation of that equipment just to ensure that it's operated to, I guess, basic standards.
Okay, so is this the type of condition that would be imposed if South Coast AQMD had gotten to the point of the process where it had issued a final permit in your experience?
Yes, these would be imposed, and then various additional conditions as well.
Okay. And so I want to focus in a little bit on the contestant elements of this. So I want to focus on in respondents category. This is actually on the next page, on page 9. They've struck out a lot of what looks like the entirety of sub-provision E. Can you explain on the left-hand side, what is sub-provision E?
So in this condition, if you go through it, you can see we're kind of trying to keep the this equipment under vacuum with the gas vapors being sent to their control equipment, the flares. So we were informed that part of the treatment system is under positive pressure. So when a system is under positive pressure, instead of air being pulled into the system, it's going to try and push out from its system into the atmosphere, which would be at lower pressure. So this is just a standard condition designed to have them, I guess, monitor those specific units for evidence of of vapor leaks due to the positive pressure. So essentially, they'd be applying a solution to the connections or possible weak points of the equipment, and then if it's kind of starts bubbling up, then you can tell that there's gas escaping.
So you said this is a standard and general condition. Do you feel like, based on what we've known and what we've seen at Chiquita Canyon, it is particularly important for this leachate treatment system?
Yeah, just due to the aspect of the liquids coming from this landfill, those vapors would be ones that we would want controlled for sure.
Okay. I'm going to take you to the top of this document and looking at, you talked a little bit about, you mentioned among the permit applications was a landfill excavation plan has been required to be submitted, correct?
Yes.
And I think you mentioned that in the interim, until that plan is issued, the order has sort of a blanket condition that holds a whole lot of sub-provisions of interim measures. Is that right?
Yeah, like some landfill excavation conditions, just general ones that may not be project specific.
And so those are laid out in condition 42N, and the parties have in these contested conditions a series of modifications that they would propose that are sub-provisions to condition 42. Is that right?
Yes.
So I want to talk a little bit more generally. Inspector Israel mentioned this one particular excavation that they're doing right now at the western toe slope excavation. Are you familiar with that proposed excavation?
Yes.
And are you familiar with any concerns that regulators, including the South Coast AQMD, have had with potential odors with that excavation?
Yes, so from my understanding, that west slope is essentially it doesn't have sufficient I guess liquid collection, liquid drainage. So the slope is likely saturated with liquids. And the leachate at this landfill, I guess depending on sample, is categorized as hazardous waste. So we expect essentially that excavation and other agencies as well, that the solids and or liquids being excavated there could be hazardous, and are likely highly odorous.
Objection, and move to strike the portion of the testimony that characterizes the waste or the all leachate at the landfill as hazardous. There are clear characterization reports that have been submitted to the regulators like DTSC and EPA that show not all of the leachate is characteristically hazardous.
I'd like to clarify that that's mischaracterizing his testimony. He didn't say all of it was hazardous. He said it could potentially be hazardous, and that would
Before
give
he-
rise to concerns.
Pardon me, before he said that the leachate at the west slope could be hazardous, he did say that the leachate at the landfill is characteristically hazardous.
Is that what you said, sir?
I thought I said depending on the sample analyzed, it could be hazardous. I don't recall saying that all the leachate at the landfill is characteristically hazardous, but I can't, I guess, remember everything that I said.
Yeah. Yeah, so our friend kind of,
The district will stipulate that to the extent that he said all leachate at the landfill is characteristically hazardous, we would agree to strike that from the record.
is that fair, Mr. Moore?
Yes, that's fine. Thank
Very
you.
well. So since there was an objection, let me just slide this in. The lunch break is at 12, it's 12:11. Was wondering how much time would you gentle folks would like to take for lunch?
The district would like an hour,
Okay.
if that's possible.
Fair enough. Mr. Kevin, our good friend Kevin, will come back at.
If it's possible, I'm about 5
Okay, not a
minutes.
problem. Go right ahead. Go right ahead.
That
and then
if
we'll
we
just-
could at least conclude direct, maybe.
No problem.
But if the chair would prefer.
No. Go right ahead. I just want to make sure if you're 5 minutes, we're good to go. No problem, Ms. Roberts. The floor is yours.
So we've been talking about this condition 42, and you testified you're familiar with the West Toe Slope excavation, and you said you were kind of explaining why that project might be considered odorous and might be of concern to the South Coast AQMD. Is that right?
Yes.
So Inspector Israel testified that this West Toe Slope excavation is occurring approximately 1,000 feet from the nearest resident. Is that your understanding?
Yes.
In your understanding, does this excavation project have to go forward? Is it necessary?
Yeah, it is necessary. I think essentially their liquid collection in that west toe slope is not sufficient currently. There may be like slope stability issues. So we agree that it needs to be conducted.
So we agree that they need to do the excavation, but we also have simultaneously pretty specific concerns of odors from this particular project. Is that fair to sum up?
Yes.
So in proposed conditions, I want to highlight one of the main differences between the parties in terms of the subparts to condition 42N. For 42N and then additional subparts in the following conditions, is it fair to say that Chiquita's proposed red lines would exempt the west toe slope project from compliance with these new provisions?
Yes.
Why does the South Coast AQMD oppose that?
We're opposed to that, I guess, due to the proximity to the residents nearby, and then due to, I guess, what is expected in terms of odor from this excavation.
So, to the best of your understanding of the West Toe Slope excavation, is that an excavation that would be subject to Rule 1150?
Yes.
So it would, in ordinary circumstances, not be able to be carried out without an approved landfill excavation plan from the South Coast AQMD?
Correct.
Are the subparts that the district is proposing to 42N, as well as the new subparts on the following page, are those the sort of provisions and conditions that would be imposed if the landfill had an approved Rule 1150 plan for the West Toe excavation project?
Yeah, those would be types that we would include in this excavation.
And if they had gone through that approval process of submitting for an approval plan for this excavation, and the district had time to review that excavation, would the district accept removing conditions from the landfill excavation plan that it thought was necessary for Rule 1150?
No.
Okay. To the best of your knowledge, when looking at these additional provisions of condition 42, uh, to the best of your knowledge, would these create a conflict with another regulatory agency's requirements on excavation that you're aware of?
Not to the best of my knowledge. I think they may be more stringent, but that would still be in compliance with another regulatory agency.
So given the status that we've heard from other witnesses in terms of ongoing odors, the testimony we've heard from members of the public with respect to odors, are these conditions to limit odors at excavations reasonably necessary?
Yes, I think so.
Thank you. Those are all my questions for Mr. Dickl.
Thank you. So we'll go ahead and break. We'll come back at 1:20. Kevin, we're off the record.
My witness has pointed to me a quick technical correction that I wanted to let you know about. So for this is 86 on the. Yeah. I don't want to.
Everyone's lost?
This was like abundantly clear.
Okay, good to know.
So maybe we do need to clarify. We're the only ones that.
I didn't think it was crystal clear.
All right, Mr. Kevin? Oh,
Yeah, if I can, I know I said I ended my direct,
no, no,
but
no, I want to make sure we get back on the record.
once we get back on the
Yep,
record,
yep.
can I have a couple more minutes of
Absolutely,
direct? Thank you.
absolutely, no problem. Okay, we're back on the record at 1:17 PM. We're going to turn the floor over to Ms. Roberts. She just needed to kind of complete and close out her direct.
Thank you, Mr. Chair. So Mr. Dickl, can I remind you that you are still under oath from when you took the oath this morning?
Yes.
Thank you. So we were talking about condition 86, and I want to remind you, can I have you turn to exhibit number 59? And condition number 86 starts on page 8, but if I can have you turn specifically all the way to the last page, page 10 of that exhibit, and looking at the last two conditions, F and G. And I don't think we talked about that difference with Chiquita and the red lines. So can I have you kind of start back and what are those provisions of condition 86 actually seeking to measure?
So if we start with the district proposed F, so we want essentially dedicated piping hooked up to the treatment process and leachate tanks to provide vacuum pull on the airspace of the tanks to vent the air or vapors to their control system. And then G is for sample ports to be installed with those vent lines essentially that monitor various things such as methane percentage, carbon monoxide, carbon dioxide, oxygen, and then flow rates and pressures.
And so in South Coast AQMD's G, which correlates to Chiquita Canyon's subprovision F, I think that's the distinction between what the parties are proposing in that condition. Can you walk me through, should that be sample ports or flow meters? And could you explain for us why?
Yes, so the district language proposes sample ports, and then Chiquita's language proposes flow meters, but I think actually it should say sample ports and flow meters, because if you flip to the end of that condition, the constituents I mentioned, methane percentage, carbon monoxide, carbon dioxide, oxygen, those would need a sample port to be measured, and then flow rates would need a flow meter to be measured.
Okay, so is the district willing to change, even though it had submitted these Exhibit 59 as the contested conditions? You're saying that it would change its version of G to be sample ports and flow meters?
Yes.
Okay, thank you. I think those are all of my questions.
All right, Ms. Morgan, Mr. Dujinski on cross.
Yes, thank you. Good afternoon, Mr. Dickl. I'm going to start by asking you a couple questions about the geosynthetic cover, which you testified about first. Do you know how much of the geosynthetic cover has been completed at this point?
I don't know the exact amount. I think it's like 38 to 40 acres, maybe. I don't know the number. It's around there. Yeah.
And the AQMD receives weekly updates on the installation, is that right?
Yes.
Do you review those weekly updates?
I try to. I review them every so often. I don't know if I reviewed the most recent one.
Would you be surprised to learn that it is 41 acres have been completed to date?
That wouldn't be surprising, no.
And do you know when that 41 acres was completed?
I don't recall exactly. I assume it was recently.
And we'll put on testimony later that I think will show it was earlier this month. Do you understand why the extension was requested? You testified earlier about an extension.
I believe, at least from my understanding, is I guess the scope changed a bit to include a larger area, and then also issues with, I guess, the conveyance lines and wells and whatnot.
And do you agree that there's only 1.6 acres remaining to be installed?
I wouldn't be able to say the exact amount remaining.
And do you understand whether this is tied to the completion of the West Slope excavation project?
Yeah, that's my understanding. That's the, I guess, remaining portion.
You also testified briefly about the flux chamber study, a recent flux chamber study. I did want to ask one clarifying question there. You mentioned there was a June study, but would you agree that the study itself took place in March, but the report was in June?
Yeah, correct. And then I think for the October study I mentioned, it maybe was August data as well. Yeah.
So August study with the report due in October?
Yes.
Okay, thank you. Just wanted to clarify that point. We also talked briefly about well drilling under 15B. Are you familiar with what a horizontal well is?
Yes.
And do you know whether there are horizontal wells at the Chiquita Canyon landfill?
Yes, there are.
And those horizontal wells, are they at a depth that is deeper than some of these vertical wells that have been drilled?
I'm not aware of that.
Do you believe that's false, or are you just not aware of where the horizontal wells
Objection,
are?
he's under oath. He can't testify to something that's not in his personal knowledge. He said he's not aware.
Well, I was asking a clarification about what he meant by whether he's aware.
So we're gonna overrule this objection, and if the gentleman can answer, then we'd love to have him to do that. If he can't, then just state that.
I'm not aware of the depth of the horizontal.
If there were horizontal wells that were deeper than the vertical wells, would that mean gas is being collected from that depth?
I guess it depends on the design of those wells and how deep they would be. So if they're like for example, if there's something at the bottom of the landfill, I wouldn't necessarily say it's collecting like the in-between portion or something like that, but that's probably not the case. It depends.
Let's turn now to condition 66, which is one of the contested conditions. I think you have that exhibit before you, is that right?
Yes.
So this is exhibit 59. Starts on page 4. So would you agree that the district is seeking to impose on Chiquita the installation an operation of this remote monitoring system in nearly 240 wells?
Yes.
And you said the purpose would be for monitoring well pressure and landfill gas. Is that right?
Pressure and temperatures.
Pressure and temperatures. Thank you. Would you agree that Chiquita already collects pressure and temperature data by other means?
Yes.
What is AQMD's rationale for requiring this installation on all of the 240 wells, or approximately 240 wells?
So essentially, if you have the real-time data for the operators, they will get a better idea of the landfill and better be able to optimize the operation of the wells.
And you need that on every single well.
I guess I can't say for every single well. I wouldn't be able to say exactly.
Could well field optimization be served with installation on a lesser number of wells?
It's possible. I guess it depends how many wells that would be, and I don't know if I would be able to answer that question.
Do you have any personal experience with the remote monitoring system?
No,
So you've never installed one?
no,
Have you ever seen one in operation?
I don't believe so.
Have you ever reviewed data that was collected from one?
I don't believe so.
Do you know if the district has ever dealt with this kind of monitoring system in the South Coast Air Basin?
I wouldn't necessarily be able to answer that.
Do you know whether these types of monitoring systems have been used routinely at other landfills generally?
Generally, yeah, I believe there's a few companies that create these for landfills, yes.
Are you familiar with the LOSI remote monitoring instrumentation
I'm aware of it, yes.
or APIS?
Yes.
And are you aware that landfills have used these experimentally at certain landfills across the country?
I guess I'm aware they've been used. I don't know about the experimental nature.
And you testified earlier that you did read the reaction committee's landfill gas wellfield automated remote monitoring plan. Is that right?
Yes.
And that was submitted in April as required by the
Yeah.
order?
Yes.
And did you read the portion of that report that stated that landfills that have used these units in routine course of operation often decide to discontinue and remove the equipment because the equipment provides no benefit to the efficiency and efficacy of landfill gas collection?
I don't recall reading that. I'd have to look and verify that.
Do you know whether these types of remote monitoring systems have been used at other ETLFs?
I'm not aware of that.
You mentioned earlier that AQMD had done its own internal study and believed that the proposed remote monitoring system would be functional. Is that right?
Sorry, can you repeat?
Yeah, you testified earlier that AQMD had done its own internal study and believed that this proposed system would be able to function in the Chiquita Canyon landfill. Is that right?
I don't remember testifying to a study that was done.
Okay. So does the district believe that the proposed monitoring system would be able to function at the Chiquita Canyon landfill?
I guess under these conditions, we're kind of trying to seek what the engineering concerns and then solutions are. So I don't think the district could say 100%. It obviously depends on the manufacturers of the systems.
And do you believe that the high temperatures might be a cause for concern and might not allow the equipment to function properly?
I think that's been mentioned. Yes.
Would you agree that chemical constituents in the leachate at Chiquita Canyon landfill may prohibit the equipment from functioning properly?
From the standard equipment, that's what I've seen in reports, yes.
And what about the buildup of debris and solids?
From the reports, yes.
And Mr. Dickl, you're an engineer, correct?
Yes.
And have you personally evaluated any equipment to see whether it would work in this proposed remote monitoring system?
No, I have not.
Would you say you're qualified to design a remote monitoring system for a landfill?
I wouldn't say I'm qualified to design one, no.
So you testified earlier that your understanding was this was some, and I don't want to misstate what you said, so please correct me if I get this wrong, but you testified that your understanding of the problem was something that Chiquita just needed to talk with the manufacturers to figure out how to solve it. Is that right?
I think that's kind of the basis of this condition, is to get that information of what has been discussed and ensure that it's like engineering solutions are being sought out. That's, I guess, my understanding.
And are you aware that numerous engineers that are qualified to install and design a remote monitoring system have evaluated this at the Chiquita Canyon landfill and determined there are serious concerns with viability and functionality?
I have been told that, I think, in meetings, but I don't think we have information on that.
Would you agree that the remote monitoring system wouldn't function well if the slots were blocked by liquids?
What slots?
In the equipment, if there's equipment in the landfill?
Yeah, I think, yeah, if there's a blockage, I would think, yeah, the equipment likely wouldn't operate as intended if it's not supposed to have a blockage.
And the Chiquita Canyon landfill, particularly in the reaction area, has a significant amount of liquid in it. Is that right?
Yes.
I mean, you mentioned earlier that you agreed that extreme temperatures may be a problem for the remote monitoring system equipment. Is that right?
Yeah, that's what the study mentioned.
And are you aware that the temperature exceedance limit or the temperature limits for the systems that are commonly operated in landfills?
Of the temperature limits, like the values?
For the remote monitoring systems?
Yeah, I'm not sure of the standard values for those now.
And would you be surprised to hear that some of the systems have run into efficiency and failure problems when gas temperatures exceed 150 degrees?
I wouldn't, Fahrenheit?
Yes.
I wouldn't be surprised, I guess, because most landfills should generally be operating under those temperatures. But I think we kind of understand that this system, like the standard off-the-shelf kind of system that could be installed here, may not work for the landfill. That's the purpose of the condition, to get engineering solutions, if there are any, to design and implement a system that would work at the landfill.
And so the temperatures at Chiquita could be over 200 degrees. Is that right?
In certain areas, yes.
And would you agree that if that remote monitoring system equipment was exposed to high temperatures, that it was unable to tolerate, it would likely have a negative impact on the function of the system?
Of the well system, or?
Of the monitoring equipment?
Yeah, if it's, I guess, exceeding what it's designed for, then it may not function correctly
So that might mean that the data would not be reliable.
in that case.
Would you agree that gas temperatures at Chiquita could be monitored within the piping network?
I guess we're aware of the temperatures at the wellhead, if that's what you're referring to.
And I believe you testified earlier that you are familiar with the concerns about whether installation of this remote monitoring system would inhibit Chiquita's ability to insert and operate pumps in the wells. Is that right?
Yes, that's what we've been told.
And did you read in the April report from the reaction committee that they suggested a pilot study for liquid level measurements?
Yes.
And was this part of that concern?
Yes, that was. But I think I mentioned in my testimony, so that liquid level monitoring isn't required under this condition language necessarily.
Has anyone from AQMD ever told Chiquita that it would not need to proceed with liquid level monitoring?
Objection. He just said that it's not required by the condition. The condition speaks for itself if it's not required.
I'm gonna overrule that objection. Because I do want to hear, I think we want to hear.
So I don't believe the district said anything because it's not a requirement to do so.
But you did see the April report where the reaction committee recommended installing sensors that would measure liquid levels.
Yes, so reading that report, if the reaction committee recommended it, then we wouldn't tell them to not do so.
But you're using that position now to say Chiquita should be moving its installation along faster, even though the reaction committee said liquid levels require a pilot study.
I think what I'm saying is that we had that initial deadline, so the reaction committee could take that information into account, and then if it's not feasible in a reasonable amount of time, they could proceed with what's required under the condition.
But that was never expressed to Chiquita until today. Is that right?
I'm going to renew my objection. She's asking if AQMD told you to do something or not do something that was not required in the first place.
So I'm going to sustain that objection based upon this line of question and the path you chose to go down. It was okay the other time, but probably should do a U-turn.
So has AQMD ever discussed the April 19th reaction committee report with Chiquita?
I do not recall.
Mr. Dickl, have you ever installed a pump in a landfill gas well?
No,
Have you ever seen it done?
no,
Have you ever pulled a pump to conduct maintenance?
no,
Have you ever seen that done?
I have not.
Do you know how wide the casings are at the landfill gas wells at Chiquita?
In terms of I guess I wouldn't be able to say specifically, no.
Do you know how far down the instrumentation would go for this remote monitoring system into the gas wells?
I believe under the report, it was stated down to 120 feet.
What would happen if the instrumentation that's sort of dangling on these cords gets tangled?
Dangling in the wells. I guess it could impact the function of the well.
And what if there's a pump in that well? Pumps sit down at liquid level, right?
Yes,
So what happens if the instrumentation gets tangled with that pump?
I guess I don't know enough about the pump operation to say necessarily.
And if a pump were to get stuck, do you know if there's any way to retrieve that pump?
I'm not sure.
If a pump is stuck, would the well be capable of being dewatered?
I'm not aware of that.
When you say you're not aware, are you disagreeing with my statement or are you not sure of the answer?
I'm not sure if that's true.
If a pump was stuck, do you know if it's possible to lose the entire gas well? For example, you would not be able to collect gas any longer?
I'm not aware of that.
And again,
I guess I don't know if I don't know.
if you are unable to dewater a well such that there's a level of liquid in there, that means you lose the ability to extract gas where there's liquid. Is that correct?
Yes,
Do you agree that extraction of liquid and gas is important to mitigating the reaction?
yes.
Why does AQMD believe it would be feasible to install these systems in approximately 240 wells by November 22nd?
Let me look. So I think if you look at the condition language there, so like I mentioned, we're asking for this information and evidence. So you can see it has this deadline, but then it says or other day as approved in writing. So I think if it's demonstrated to not be feasible, based on the information we receive, and if Chiquita did due diligence with contacting the manufacturers and trying to get a system designed, then essentially, if that's provided, South Coast AQMD would have the ability to extend that timeline. So I wouldn't say that timeline's a hard deadline.
Why did you select November 22nd in the first place?
I am not aware. I don't think I can speak to that specific date.
So if AQMD is willing to entertain evidence that shows this system might not be feasible and then revise that date, why is AQMD opposed to the proposal of Chiquita to do a study to address the functionality and viability and then review those results?
I think, I guess I can't really speak to
I'd
Chiquita's
object to
proposal.
counsel passing notes to the witness who's testifying.
For the record, the note says, "Don't guess." I am just ensuring that the witness is aware that he should not guess on topics that he is not sure about. I'll make that for the record.
The objection is sustained.
Sorry, could you repeat your answer?
Sorry, could you please ask the question again?
Yes.
Sorry.
Okay, so if the district is willing to entertain evidence as to why this system, as to why the November 22nd date does not work, why is it opposed to Chiquita's proposal of determining with a small number of wells the functionality and viability of the system and then presenting those results to the district?
I think I can't speak fully to that, but I guess, hold on, I lost my train of thought for a second. Sorry, let me just read Chiquita's proposal. So I guess I can't speak fully to that, but I would say we don't have the evidence of that information that Chiquita is stating.
Because you believe the April report was insufficient?
Yeah, I don't think it goes into, we just became aware a week or two ago of, I guess, a lot of the information and the fact, like we assumed that Chiquita had achieved the June 21st deadline to have contracts to install and operate the system. So we hadn't heard anything on that. So we assumed it was moving forward as stated in the condition.
So I think you said you don't know why the November 22nd date was selected. Is that right?
Yeah, I can't speak on that specific date.
Have you contacted any manufacturers about whether the capacity to provide this type of equipment by November 22nd?
I have not personally.
Has anyone at the district?
I am not aware. I can't speak for others.
Have you contacted any engineers to determine how you might design or engineer this type of system?
I have not personally.
Has anyone else at the district?
I can't speak to that.
Have you contacted any other landfills to determine whether they have a remote monitoring system and how they operate it?
I have not.
And has anyone else at the district?
I'm not aware.
Have you contacted any suppliers or manufacturers or distributors about the availability of components?
I have not.
And has anyone else at the district?
I'm not aware.
Do you know what goes into the fabrication of one of these devices?
I wouldn't say I do know.
Do you know how many different vendors supply parts to create one of these devices?
No.
Earlier, when you were testifying about 66, both C and D, you noted that the difference between the proposals is that Chiquita proposes adding the word distributors to both. Is that right?
Yes.
And you testified that you think this is more of an engineering problem than a distribution problem. Is that about right?
That's my understanding, yes.
Now, in this condition 66, you've also mentioned that, let's see, 66 subpart B would require submission of all known design, implementation, installation, specification issues or concerns. Is that right?
Yes.
What if one of those concerns was supply chain availability? Would it be reasonable for Chiquita to be reaching out to distributors to determine the availability of equipment?
If that was the case, yes, but from what we've been told and what we know, it's more of a physical design issue. So I don't think we have that information currently.
Why do you think that?
I think
That it's not a supply chain issue?
Objection asked and answered. He included an explanation in his answer.
He just said that he didn't think it was a supply chain issue. So I'm saying, why do you think that?
Objection. He is supplied in his answer. He was not told from Chiquita. That was his testimony. He said he was told that it was mostly design manufacturer issues.
And he said from other information provided. I'm just trying to understand why he believes. And if the answer is it's just because what he's been told by Chiquita, that's fine. I'm just trying to understand why you believe that it is not a supply chain issue.
So you like to rephrase the question perhaps?
Sure. So why is it that you believe there's not a supply chain issue?
I wouldn't have the information to say yes or no on that.
But you would agree that if one of the issues that was reported under 66B was supply chain concerns with the ability to procure equipment, that it would be reasonable for Chiquita to reach out to distributors to address those concerns.
I'm going to object. It calls for speculation. He can't testify to what might be if he had information that he has not been given.
I'm just asking him a hypothetical. Would that be reasonable in that instance?
That essentially is vague. It would depend on what information he would be given in order to say, would it be reasonable to include different language in the condition if the information that Chiquita provided was different than what it is?
Yeah, the objection is sustained. You want to rephrase?
Sure. So what if, under condition 66B, Chiquita reported that it had reached out to multiple, manufacturers or distributors for a certain piece of equipment that it wanted to install with its remote monitoring system. Those manufacturers said, distributors said they had a backlog of orders and they only had 10 parts that they could provide. Would it be reasonable for a next step for Chiquita to be to reach out to different distributors to see if they had parts that were available?
I guess reaching out to different distributors would make sense in that case, but I am not aware of that being an issue necessarily.
You testified earlier that the purpose of this remote monitoring system would be to optimize well field tuning. Is that right?
Partially, yes.
How else would you describe the purpose?
I guess, yeah, it's mainly that just providing real-time data to the operators. So essentially, yes.
Do you believe that Chiquita has issues with well field tuning?
I couldn't speak to that.
Are you aware of whether when Chiquita has some exceedances, it has generally been able to correct that in the first 10-day period?
Surface exceedances, or are you referring to like 1150.1 monitoring, or what exceedances?
Yeah, the surface exceedance monitoring, exactly.
Yeah, I've looked at those reports.
And so you'd agree that Chiquita's generally been able to correct that, any exceedances in the first 10-day period?
I wouldn't be able to give a breakdown. I mean, I've seen some extend to 20 or 30 days. I don't know the breakdown.
What's AQMD's opposition to ensuring the functionality and viability of a system before proceeding with full installation?
I don't think AQMD has opposition to that.
You testified earlier, Mr. Dickl, also about permits and permit applications and had a long list of permits that are pending. Is that right?
Yes.
You also mentioned that there have been some ongoing exchanges between AQMD and Chiquita about those permits. Is that right?
Yes.
In your experience reviewing permits and permit applications, is that type of exchange typical between an applicant and the district?
Yeah, it depends how complex, but it's typical.
You also testified about another contested condition, condition 86. We could turn to that one, please, in Exhibit 59. So as we read through this, Chiquita has agreed to the proposed condition subpart A and subpart B. Is that right?
Yes.
And Chiquita's only disagreement on subpart C is the date. Is that right?
Yes.
Could you please turn to the stipulated conditions and look at condition 76? And that's on page 12. So do you see the first sentence where it says respondent shall install sample ports on all equipment on the site that requires sampling to prevent unnecessary fugitive emissions from sampling activities?
Yes, I see that.
And is that essentially the same requirement in the contested condition 86C?
I let me scroll back to 86C. So 86C is relating specifically to the liquid condensate and leachate treatment and storage. And then 76 look like it's just much more general. And I think, yeah, I'll leave it there for now.
Okay, so you see in stipulated condition 76 that the parties agreed that these sampling ports would be installed by December 2nd. Is that right?
Yes.
So why is that same language not in condition 86?
Sorry, I'm just going back through each one. So I think since 76 is more general, it provides an extended timeline, but 86 C is specific to this leachate treatment and storage equipment. So that's why the timeline is tighter.
What other equipment on site requires sampling?
So we're not aware of that. That's why it's a general condition in the case. So I think South Coast AQMD had thought that the leachate tanks had sampling ports, but they do not. So this is a general conditions. If there's other equipment that we require samples of, it shouldn't be opening the hatch to get a sample. It should be from a sample port.
But you're unaware of any equipment that requires sample ports other than the leachate tanks?
I'm not aware currently, but that's why it's just a general condition.
Would you expect fugitive emissions from taking a sample to present a significant risk of odorous emissions?
It depends how the sample is taken.
Let's take a step back and talk about 86 a little bit more broadly. I think you testified before that these are general requirements that are typically imposed in a permit. Is that right?
I guess in a permit for this type of leachate treatment and storage, yes.
So are these conditions customized to Chiquita?
Am not aware. I think some of them are general, some may be slightly customized to the landfill.
So you testified earlier about condition 86E, which would require inspection of the liquid treatment system equipment under positive pressure for vapor leaks at least once a day. Is that right?
Yes.
What is that equipment that would need to be tested?
So I guess we are still going through the leachate treatment system applications, so we don't have a complete full understanding. We're still requesting information on it. So I can't say to that. I can just say that we were told by Chiquita there's some equipment under positive pressure.
So if you're still going through the applications and materials, are you aware that there is no vapor in the equipment that is under positive pressure?
I wouldn't be able to, I guess, agree with that necessarily. I don't have the information.
Say hypothetically, if there were no vapor, would you agree that inspecting for vapor leaks would be unnecessary?
I'd say if South Coast AQMD could verify that there's no vapors based on like the engineering information, then this condition likely wouldn't apply to that.
Are you familiar with the process for the leak inspection that AQMD proposed in this condition?
Yes.
Are you familiar with the safety concerns with that process?
I'm not aware of the concerns on the site.
Have you ever conducted such an inspection yourself?
No.
So if this equipment had no vapors, would you agree that the key inspection would be about liquid leaks?
I don't think this condition would necessarily apply to liquid leaks.
Are you familiar with the requirements imposed by other regulators on Chiquita relating to the liquid treatment system?
I believe the EPA, I wouldn't be able to speak to all of those requirements.
Are you aware that Chiquita is required to check the tanks in the liquid treatment system daily for leaks?
Liquid leaks?
Yes.
I'm not aware of that requirement.
So looking at the rest of the condition, I think you testified earlier, but just to clarify, Chiquita agrees to the language that is in the district's 86F. Is that right?
Agrees or disagrees?
Agrees. And that's why I want to clarify on the left-hand column, it's the district's proposal. It's section F, subsection F. And on the right-hand column, it's Chiquita's proposal and it's the same language, but labeled subsection E. Is that right?
Oh, yes, yes. Sorry, I was looking at the wrong column.
So I just wanted to clarify for the record that Chiquita and that the parties agree on that particular subsection, right?
Yes,
Okay.
yes.
I just inquire on that because we verbally were told they added end flow meters, so that's what you're agreeing to.
No.
No, I think that's subprovision G on the districts, and I think that would be correlate to subprovision F on Chiquita's side.
Correct. Okay, so F on the district side and E on Chiquita's side are agreed. But as Ms. Roberts just stated, if we look now at what is the language in G on the district side and the language in F on Chiquita's side, there is one point of disagreement here. So it's your testimony earlier, just a little bit ago, that the district would say sample ports and flow meters would be tested. Is that right?
Yes, that's correct.
So this would require daily samples via the sampling ports and flow meters associated with the leachate treatment or storage equipment. Is that right?
Yes.
Do you know about how many pieces of equipment that is?
I'm not aware of how many pieces now.
Do you know how many leachate tanks are at the landfill?
Yes, 251 from my knowledge.
So it would be at least 251 samples, is that right? Based on the district's proposal.
Um, so I think, so if we're saying flow rates, I don't know if that necessarily applies to an individual leachate tank.
So is the district's position that this would not require sampling at each leachate tank, this particular subcondition?
I guess I couldn't speak to that on how many tanks or how many lines from the tanks this is that are required under this.
These samples that would be required under this condition would need to be taken to a lab for analysis, is that right?
I believe so.
Let's say if there were 250 samples that needed to be taken to a lab every day for analysis, are you aware of whether there are labs that could handle that capacity?
I wouldn't be able to speak to the labs.
Do you have any idea how many samples Chiquita is already required by its various regulatory obligations to send each day to labs for analysis?
I'm not aware.
Would it be fair to say that the purpose of this particular subpart is to measure landfill gas wellhead data across the leachate treatment and storage system?
Yes.
Why would it be necessary to do that at over 250 locations?
I guess my understanding of the condition is more on the vent lines from those tanks.
So your understanding of the district's proposal is that this only requires taking samples at the vent lines, is that right?
Yeah, it's to get an idea of, I guess, what's coming off the tanks and I guess the treatment system itself.
And do you understand that that is what Chiquita proposed and why they proposed taking these samples at the flow meters?
I think so. We're not aware of flow meters, I guess, being able to accurately categorize all these items required. And then if they can measure it, we're not sure if it's necessarily appropriate, but that would be, I guess, handled by our source testing staff on like appropriate location of a device.
So is it the district's position that the disagreement then is not on the number of samples? You'd agree that there's only a limited number of samples that are necessary?
I think so. I don't think the intent was to have 250 samples. Per day. Yeah.
I'd like to turn next to the contested conditions 42, the new subparts. I think that's at page 1 of this document of the chart of proposed contested conditions. So I think you testified earlier that sort of similar to condition 86, many of these new subparts are sort of an interim measures until Chiquita has an 1150 plan. Is that right?
That's, I guess, the basic purpose of condition 42, yes.
And so when we're looking at the contested conditions, which is the revision or the modification to 42N and the new subparts to 42, were these proposals from the district independently evaluated and proposed for Chiquita specifically?
I believe so. Well, I guess a lot of these are standard language, like for example, 42N is a standard condition.
And so were these proposals, did they take into account the ETLF conditions at the Chiquita Canyon landfill?
I can't really, I guess, answer that.
Did they take into account the particular conditions of the West Slope excavation project?
We reviewed the West Slope work plan and are aware of the the issues. Yes.
Are these proposed modifications or subconditions copied from other 1150 plans?
I guess it depends on the conditions. A lot of them are standard, but there may be slight modifications based on this particular landfill.
So let's look first at 42N. So, left-hand column is the district's proposed modification, right hand is Chiquita's. Do you agree that Chiquita agreed to, well, first of all, this condition, it's about how quickly Chiquita would need to cover an excavation site, is that right?
Yes.
And would you agree that Chiquita agreed to change the timing from 2 hours to 30 minutes, safety permitting?
Um, 1 sec. I have a question on the district language really quick, if I can just ask.
I'd object to that.
Yeah, so why don't we just take about a 5-minute recess? Thank you. We're off the record, Mr. Kevin. Back. Okay, we're back on the record. I'm going to turn the floor back over to our witness. You needed a time to confer.
Yes, should I answer? Okay. See, I wasn't aware of the district's proposed language. It might have been updated, but I agree that there's agreement on those 30 minutes and safety permitting.
Thank you. And do you see the language on Chiquita's side where it says, or unless otherwise approved in writing by South Coast AQMD?
Yes.
Do you know why AQMD disagrees or contests that language?
I think we aren't aware really of a case where that would be approved outside of the safety permitting. So I think it's encapsulated in that addition there.
So you object to the option that Chiquita could approach South Coast AQMD with a reason why it might need more than 30 minutes?
We don't see a reason for it based on the language.
So I think you testified about this earlier today, but the sentence that Chiquita adds at the bottom of 42N would exempt the West Slope excavation project. Is that right?
Yes.
But only if Chiquita followed the work plan. Is that right?
Yes.
And I think you testified earlier, you've seen that work plan. Is that right?
Yes, I've seen it.
You testified earlier about the purpose of the West Slope excavation and that it was important to address the leachate collection system at that area. Is that accurate?
Yes.
Are you aware of the timeline for completing this project?
I guess I'm not aware of when it will be completed. I know it's trying to be completed quickly.
Are you aware that it's important that the project is completed quickly?
Yes.
And that's because the excavation work and the project, once completed, would actually improve air quality and emission of odors. Is that right?
Objection calls for speculation.
Yeah, the objection is hereby sustained.
Do you believe that the excavation work would improve air quality?
Objection calls for speculation. He can't testify to what might occur at the end of a project he's not actually carrying out.
He's an engineer who's qualified in these types of issues. I'm just simply wondering what his opinion is on this project.
Okay, the objection is hereby overruled. So we'd love to get your opinion.
I wouldn't necessarily be able to say on the, I guess, reduction of odors from the project.
Do you understand that it's also important to complete this project in a timely manner and in advance of the impending rainy season?
I believe that was in some of the information I reviewed, yes.
When does the rainy season start in this area?
I guess it depends on the year, maybe December. I couldn't say.
Are you aware of the discussions between Chiquita and its regulators that the work was aimed to be completed by October to avoid rains?
I believe I've seen the timelines, yes.
And you mentioned that you have seen the work plan. And do you understand that the work plan was reviewed and approved by the Response Multi-Agency Coordination Group at Chiquita?
I'm not aware of the approval necessarily. I haven't seen that.
Are you aware that there was significant discussion between the regulators as part of that RMAC group about this work plan?
Yes.
And the regulators that were a part of that RMAC were all given the chance to provide comment on the work plan. Is that right?
Yes.
AQMD is a part of that RMAC group, right?
Yes.
So AQMD provided comments on the work plan. Is that right?
Yes.
Do you personally participate in those discussions?
Yes.
You understand that Chiquita is subject to a unilateral administrative order under the EPA's Circle Authority. Is that right?
Yes.
and that EPA has directed Chiquita to proceed with the West Slope project?
I'm not aware of the directive, but
So you stated that you don't believe there's a conflict between the work plan and these proposals of the districts here. Is that right?
I'm not aware of conflicts necessarily, no.
Do you agree that the AQMD's proposal would slow down the project?
It would be hard for me to say that necessarily.
The West Slope excavation has started, is that right?
I believe so.
Have you been there?
I have not.
So you don't know whether there are odors coming from the excavation project?
I'm personally not aware.
So let's look back to the specific language in 42N about covering an excavation site. Would you agree that this language is not found in the approved work plan?
From my understanding, that's correct.
Are you personally familiar with how long it would take to cover a section that's been excavated at the West Slope?
I can't, I guess it depends on how something is prioritized.
Have you ever personally been involved in pulling a tarp to cover an excavation area?
No.
Are you familiar with the safety concerns at the West Slope?
Yes.
And have you been to the West Slope since the reaction began?
I don't know if I've visited the West Slope area. I don't believe I have.
Why do you believe that the tarp could be pulled in the West Slope in 30 minutes?
I don't think this condition necessarily requires a tarp only.
What other options would there be?
So it lists 6 inches of clean soil, plastic sheeting, which is the tarp, or other South Coast AQMD approved cover.
Would you agree that covering with soil would take longer than pulling a tarp?
I guess I couldn't speak to that.
Are you familiar with sort of the steps in the project? Once Chiquita digs out the reacted material, what comes next?
I guess my understanding is excavating and then laying stones, gravel, piping, and then covering. I don't know I can't recall off the top of my head like the finer details.
So you do understand that there's sort of layers though, there's steps to this, right?
Yes.
And so you think it's possible to lay the rock, the gravel, then the soil cover on top in all under 30 minutes?
I don't think that's necessarily what this condition requires. And I guess it depends on the cover that's used.
So what cover do you think could be accomplished in 30 minutes or less?
I guess one off the top of my head would be some type of foam cover.
Are you aware of whether the work plan allows that?
I don't recall.
Would foam be the final cover when the project is complete? Or would that be an interim cover?
Project complete meaning the landfill is like the geosynthetic cover is back on, or for a specific day?
So you go through the process, you are repairing the liner, you're repairing the pipe, you're putting in the gravel, the rocks, the liner. Can foam be the top layer?
No.
So that would be, you hadn't finished and you're going to come back the next day, you could use foam conceivably.
I think it depends on and I think there's a condition in there. I think it might depend on the weather if the foam can be used.
But ultimately, there would need to be soil and then a geosynthetic cover once the project's complete. Is that right?
Yes.
And do you believe that soil could be placed in 30 minutes?
I wouldn't be able to say. I think I would think that foam could be placed and then soil placed on top of that.
You said you haven't personally witnessed the West Slope excavation project underway, is that right?
I have not.
Have you asked Chiquita how long it has been taking them to cover their excavation work faces at the West Slope?
I have not.
So let's turn now to the next subparts of condition 42. So there are, let's see, there's 1, 2, 3, 4 subparts here that are contested, 4 new subparts. Would you agree with that?
Yes.
So let's turn quickly now to the stipulated conditions. There are a number of additions or modifications to condition 42 that Chiquita agreed to. Is that right?
Yes.
So if we look at the bottom of page 8, there's a modification to 42K where Chiquita agreed to reduce the time for on-site burial from 2 hours to 1 hour. Is that right?
Yes.
Now we go to 42M. Chiquita there agreed to a proposal regarding the rumble strips. Is that right?
Yes.
42O is just correcting some typos. Is that accurate?
Yes.
Okay. 42T. Chiquita agreed to a new condition that would apply to all excavations, including the West Slope, that odor neutralizer would need to be applied during excavation. Is that right?
Yes.
And we look at 42U. Now here, Chiquita has agreed to a new condition that will apply to all excavation in the reaction area. Is that right?
Yes.
And the West Slope project, that's in the reaction area, correct?
Yes.
And this condition requires Chiquita to use bed liners while excavating. Is that right?
Yes.
Now we look at 42V. That is another condition that would apply to any excavation, including the West Slope project. Is that right?
Yes.
And
I'm just going to object as this is cumulative and we can read all of these conditions. They speak for themselves.
And to be very honest, I'm inclined to agree with Ms. Rack. I'm going to sustain. We have a tremendous amount of declarations. There's a lot of documentation. So if we can move it along, we have a hard stop at 4. But again, it's your time.
thank you. And I'll just for the record explain that the purpose of this line of questioning is to point out that Chiquita was particularly agreeable and did agree to add many conditions to 42, including the West Slope
Objection, this
project.
is better placed in a closing argument. This is not appropriate
I was just
posturing
responding to
for
the
the middle of
objection
testimony.
and you interrupted me.
Ready, Ms. Morgan.
So without actually going through each of these individually, as I hear Mr. Chair's request there, there's 42V, 42W, 42X, additional conditions that Chiquita has agreed to that would apply in all excavation, including the West Slope. Is that right?
Yes.
So let's turn back to the contested conditions. Would you agree that the new subparts to 42, generally speaking, Chiquita's, main point of contention is that these would apply to the West Slope project?
Yes.
Do you understand that Chiquita's main point of contention is that these particular conditions would lengthen the time that it would take to complete the West Slope project?
I'd say we understand that, but I guess the district's purpose is finding a balance that the project shouldn't be done quickly at the expense of the surrounding community.
But you do think it should be completed?
Yes.
So if we look at 42, this is subpart I on the district's proposal, it would limit an excavation work phase to 1,000 square feet. Is that right?
Yes.
Have you ever conducted construction work at a landfill?
No.
Excavation work at a landfill?
No.
Have you ever installed drainage pipe?
No.
What makes you think it's feasible to conduct the West Slope project with only a 1,000 square foot work face?
So as I mentioned, the work face you can excavate and then you can cover as you go. So this essentially we would want the exposed material to be covered quickly, whether it be foam or other item. So we believe that Chiquita could cover with foam and keep the excavation work face to 1,000 square feet.
And this isn't in the work plan though, right?
I don't believe so.
And the work plan allows excavation in 75 to 100 foot linear segments. Is that right?
From what I recall, I remember that being mentioned.
And are you familiar with the height of that area? So it's 75 to 100 feet wide. And the height is is at least 30 feet. Is that right?
I've seen the height. I don't recall what it was.
But do you understand that this condition would require Chiquita to cut the working face, the excavation working face, by over a third?
I can't speak for those other numbers.
Do you think it's fair to say that if this required to cut the excavation work face by at least a third, that it would triple the length of the timeline?
I couldn't answer that.
Chiquita has also proposed an exemption here. So to be clear, Chiquita would agree that this would apply to excavation at the landfill, just not the west slope. Is that right?
That's the proposal, yes.
Chiquita did have one particular edit or modification though, where that says except where immediate excavation is necessary for the protection of public health and safety. Do you see that?
Yes.
Why does the district oppose that?
I don't know if I can speak for the entire district, but from my understanding is with the ETLF event, I guess the site could claim that every excavation meets that criteria. So I think it may be something to do with the language, but I can't speak fully on the reasoning for that.
If the ETLF were not considered as part of that, or if there was some way to rephrase that, would the district agree to something that had a carve out where excavation was necessary for immediate protection of public health and safety?
I couldn't answer that myself. It's not just up to me.
So if we turn now to Romanet 2. This subcondition would require additional mitigation measures upon receipt of a Rule 402 notice of violation. Is that right?
Yes.
And the language here is not specific to a Rule 402 violation related to the excavation, correct?
Correct.
How often does Chiquita receive Rule 402 NOVs?
I'm gonna object. He's not the appropriate witness for this because he doesn't work in our compliance department. We did have a witness speak to this particular provision who is from our compliance department, who can speak to notices of violation and their frequency of issue. I do think he did testify to that.
So did you hear the earlier testimony that Chiquita receives frequent Rule 402 NOVs?
Yes.
So would it be fair to say that this condition would be triggered frequently, particularly during this West Slope project over the next several months?
I couldn't.
Objection. That calls for speculation. And again, he is not a compliance witness. He cannot speak to when a compliance notice of violation might be issued.
Well, he commenced to answer. I want to override that objection, and I would like to hear whatever you were getting ready to say.
I was gonna say I couldn't answer that.
Okay, fair enough. You can't answer it.
If you look at the approved mitigation measures on this list, mitigation measure B says limiting the excavation work face by reducing the area by at least 50%. Is that right?
Yes.
So that would slow down the excavation project. Is that right?
Are you saying because that would slow down or it would
By
slow
limiting
down?
the work face by 50%.
Sorry, can you?
Sure. So if the excavation work phase were reduced by at least 50%, that would extend the time needed to excavate. Is that right?
I guess I couldn't speak for, I don't know all the details of the excavation.
And based on the district's proposal here, there is no way to return to a full excavation work phase during that day. Is that right?
From from listening to Inspector Israel, that is my understanding from his testimony, yes.
So let's look now at subpart 3, Romanet 3. So this proposal from the district, to summarize, says that if certain triggers are hit, excavation would need to cease. And these same approved mitigation measures would need to be implemented for the rest of the day. Is that a fair summary?
I believe so. I think this is more of our monitoring staff who might have input on this condition, but that's my understanding of how it reads.
And so again, if excavation had to cease and the work phase was then limited by 50%, that would extend the time needed for the excavation project. Is that right?
I can't speak on the timeline.
Are you familiar with the, and if you're not, just say so. Are you familiar with the provisions in Romanet 3 about the ambient monitoring stations?
The requirement for them or the ambient monitoring stations in general?
Yeah, the requirement here says that these approved mitigation measures would need to be implemented if 25% or more of the ambient monitoring stations are down. So are you familiar with the reasoning for that?
Yes.
And why is that?
Essentially, so this condition is, it's looking at the ambient air monitoring station data, and if there's exceedances, then the mitigation measures should be implemented. So if there's monitoring stations that are down, we would not be getting that data. So in those cases, if there's no data, it should be assumed that those monitors could be having high levels.
And Shikita agreed to this language, the 25% or more are down for excavations other than the West Slope project. Is that right?
Yes.
And you said you read the West Slope work plan. Have you read the West Slope health and safety plan?
I think I looked at it. I don't know as much about that one.
Are you familiar with, or are you aware that it was approved by the EPA and Chiquita's regulators?
I'm not aware of the approval.
And are you familiar with the air monitoring provisions and requirements in that West Slope health and safety plan?
I'm aware of some which are part of these Rule 42 conditions. I'm not aware of possible other monitoring requirements.
And are you familiar with the stop work provisions in the West Slope work plan?
I don't recall them.
So this particular subcondition would be in addition to the air monitoring of the air monitoring that is in place in the West Slope health and safety plan. Is that right?
Yes.
And Chiquita's proposal, when we're speaking of excavation outside of the West Slope, would be that Chiquita struck the language that said when one ambient air monitoring station downwind of the work face is down, that excavation would need to cease. Is that right?
Yes.
And why does the district think that having 11 functioning ambient monitoring stations is insufficient if all 11 are not showing rel exceedances?
Because of the term downwind in that sentence. So you can have other monitoring stations at other locations around the landfill, but if the one that's downwind getting the air from the landfill is offline, then we think the mitigation measures should be implemented.
The district's proposal does say when an ambient monitoring station downwind, not all downwind stations, is offline. Is that right?
I guess it depends on the location of the of the monitor.
So let's look next at Romanet 4. The first sentence here in the district's proposal says during excavation, other emission generating activities such as well drilling in the reaction area should be limited and prioritized outside of excavation hours. You're aware that the West Slope excavation project will take 6 to 8 weeks or potentially longer if the district gets its proposals here. Is that right?
Yes.
So during that time period, the district does not want Chiquita to drill wells. Is that right?
It says outside of excavation hours, so it's not necessarily a prohibition on doing those activities.
Do you know how long it takes to drill a well?
I'm not aware of that.
And you are concerned with ensuring wells are drilled to depth, correct?
Yes.
And deeper wells take longer, is that right?
Yes.
Do you think that a well could be drilled in 2 hours at the end of a workday?
I don't think it can be drilled in 2 hours.
Are the deeper wells, do they sometimes require multiple days to drill?
Objection, he's testified that he has no knowledge of well drilling.
He's the
Well
district's
drilling.
expert on
Could you-
well
If you
drilling.
could just let me finish, please.
Apologies.
He said he's not familiar with that. He has not been on site for this. And she's asking for him to speculate on something he's already testified he doesn't have personal knowledge of.
The district presented this witness to talk about well drilling conditions as their expert.
The district presented this witness to talk about the specific well provisions in this abatement order, which he is familiar with and can speak to. That does not make him an operator of a landfill or an operator of a drill rig. There's a difference between being able to draft conditions of an abatement order for the purpose of abating a public nuisance and operating a landfill. Those are different expertises.
Objection is sustained, but let me ask you a question. Is somebody on staff that can answer these questions she's positing?
I don't believe we have any landfill operators on staff to my knowledge. The questions are, those questions that she's asking are more appropriately addressed to Chiquita's own witnesses who do conduct well drilling.
Ms. Morgan, floor is yours.
The district is presenting proposals that it apparently doesn't know how to support. So we're simply asking, are you aware how long it takes to drill a well? Because if it takes too long, then we wouldn't be able to prioritize it.
Objection, we move to strike. That's not an appropriate objection. That's characterizing and is it better appropriate for a legal argument in closing that to say that the district is not prepared to support them. The objection was already sustained. The chair gave a ruling that should end the inquiry, and please go back to questioning after a ruling has already been issued.
I apologize. I thought you were asking for my response to the objection.
I welcome your response, and it's so noted, but we have indeed ruled, and I believe we ought to proceed forward with questioning and examination.
So other than addressing the prioritization of well drilling, this subpart 4 also addresses mitigation measures that would need to be implemented during landfill gas collection and/or control equipment breakdown or maintenance. Is that right?
Yes.
And again, this refers back to that list of mitigation measures that includes reducing the size of the excavation workface. Is that right?
Yes.
Chiquita agreed to this language with one modification for any excavation other than the west slope. Is that accurate?
Yes.
That specific modification, if you can see in Chiquita's language, it says resulting in reduction of gas flow to control devices by 10% or more. Do you see where it says that?
Yes.
And would you agree that that is overall consistent with the district's proposal, but seeks to put a definition on the time at the breakdown or maintenance?
Objection, it's a vague question. What do you mean by it's consistent with? If there's a disagreement there, could you just object to vagueness?
Objections overruled, but go right ahead, Ms. Morgan. Let's try
Yeah.
to rephrase it up.
I can clarify. So Chiquita agrees that if landfill gas collection and or control equipment is offline due to breakdown or maintenance, in certain circumstances, it would implement approved mitigation measures for all excavation outside the West Slope project. Is that right?
Yes.
And Chiquita is trying to add in a definition. So when equipment is offline due to breakdown or maintenance, resulting in a reduction of gas flow to control devices by 10% or more. Is that right?
Yes.
Why does the district contest that particular definition, 10% or more?
I think I would have to check on that because I'm not familiar with, I guess, that portion of that condition. I think there was a similar condition where there was a similar measure implemented, so I think I would need to, I guess, check on that to answer that fully.
We have another engineering witness that we plan to call as a rebuttal to the cross, so perhaps some of these questions could be answered by that witness.
Could you look at the last sentence of,
Well, hold on, was that an objection or just a statement? Is that an objection to her?
No, that was for the board's edification. When you had asked earlier if we had somebody that could talk to a different issue, I was just letting you know we do have someone that can speak to this issue.
There you go. Hold on, Ms. Morgan.
and so Mr. Dickl, if you could just turn to the last sentence of this subpart 4. Now here, the district's proposal says this log shall be made available to South Coast AQMD in a weekly report. Is that right?
Yes.
And are you familiar with the cross-reference there?
In the district's language, condition 9, is that? Yes.
Can we turn to condition 9 and see if there's a cross-reference there, a weekly report?
I think,
It may have changed to condition 8. Is that numbering?
And condition 8 is.
Yes, the district will stipulate that that's a typo that should reference condition number 8 for the monthly report, I believe.
So you see Chiquita's proposal to say the log would be made available within 48 hours of request. Is that right?
yes.
And so the district disagrees with that position.
Yes.
I've got no further questions. Thank you.
All right, members of the board, did you have a redirect?
Yes, we
Okay,
will have
go
a
right ahead.
redirect.
Go right ahead.
Sure. Mr. Dickl, I want to take you back to the contested conditions and back to condition number 66, and that starts on page 4 of exhibit 59. Can I have you turn to that? And you testified that you were familiar with the recommendations from the reaction committee that were submitted pursuant to the original version of condition 66. Is that right?
Yes.
In that feasibility recommendation study, did the respondent provide any evidence that the landfill gas temperature monitoring or monitor well pressures was infeasible?
There wasn't evidence that it's infeasible.
Did they provide any indication that to achieve the monitor well pressure and landfill gas temperatures that are required by condition 66 would require a pilot study?
Those were not mentioned as requiring a pilot study in that report.
Okay. And so is it fair to characterize, we kind of walked through A, B, and C. Is it fair to characterize that what we are seeking in those provisions is the evidence of information that Chiquita has later provided to us outside of those specific recommendations that are in the condition?
Yes.
Is it essentially like, give us your proof? Is that a fair summation of what those conditions are?
Essentially, yes.
Okay. And I think you were having a discussion with Ms. Morgan regarding distributors being excluded from subprovision C and subprovision D. Is that right?
Yes.
And did Chiquita, prior to today in your testimony, did you receive information from Chiquita that supply chain issues were also a concern that would prohibit or preclude timely implementation of the system required by condition 66?
I have not received information on that.
Okay. So is it fair to say that we included the types of information based on the information that Chiquita provided to us as the reasons for why the system might be behind schedule?
Yes.
Okay. Is it fair to say that if we don't use the word distributor, essentially assume South Coast AQMD's version of 66, would that preclude Chiquita Canyon Landfill from calling a distributor?
It would not.
Would it preclude Chiquita Canyon Landfill from providing us information that it received from a distributor if it called a distributor?
It would not prohibit that.
Is that the same for condition number D?
Yes.
Okay. I do want to take you down further a little bit to condition number 86. And I think you, in your affirmative testimony, you first said this is essentially a standardized type of condition. And then in discussion with Ms. Morgan, you clarified it is a little bit specific to Chiquita system to the extent we know about that system. Is that fair?
Yes.
And you walked through all of the numerous permits and permit applications that have to be gotten and obtained for this leachate treatment, landfill gas collection, this entire process. Is that fair to say?
Yes.
Is it fair to say that at this point, this is unusual for how engineering and permitting would typically go about permitting a system?
Yeah, we would, I guess, permit it before it's installed and operating.
Okay, so is it, at this point, is the district's proposal in condition 86 effectively to add additional conditions because we learned additional information about how they are operating this system?
Essentially, yes, and it's general conditions, not specific, and not like very specific conditions of how they have to operate. It's more general because we're still gathering information on the system.
So in sub-provision C, I think Ms. Morgan kind of walked you through a comparison with the specific condition for installing sample ports in condition 86 that has a different deadline than what you referred to as the more general condition, that is the stipulated condition about installing sampling ports. Is that right?
Yes.
Did we include the requirement to install sample ports in this modification because we learned something about how Chiquita Canyon was installing or collecting samples?
Yes, so we learned that they don't have any sample ports, or I shouldn't say any, but we learned that they don't have sample ports on the leachate tanks. So we believe that they've been collecting liquid samples to send for analysis for characterization of the waste by opening the tanks and collecting samples.
So in general, do we ever require samples collected as part of regular source testing or regular monitoring for any type of equipment permitted throughout the South Coast AQMD that you know of?
Yes.
Is there any time when we would permit sampling from the method that we learned Chiquita Canyon is doing?
No, we would want the sampling method to be contained to not have odorous or any type of emissions escaping to the atmosphere.
So that's true of equipment even when a facility is not creating an ongoing public nuisance?
Correct.
And that's true even when the equipment and the compounds at issue that are being sampled are not characterized as hazardous waste?
Correct.
Thank you. I want to take you up to the first of the contested conditions. I think Ms. Morgan walked you through conditions, the subparts to condition 42 that are contested. Do landfills specifically in a typical scenario, do they get a new excavation plan under Rule 1150 for every excavation that they do in normal circumstances?
I guess it depends on how they submitted the application and when they submitted, but they can do either. They can submit a plan for one excavation project if that's all they're planning to do, or they can submit a general plan kind of that lasts for the next 5 years or so.
So in your experience, do most large Title V landfills within the South Coast AQMD have a generalized Rule 1150 plan approved so they can carry out regular excavations?
Yeah, they generally would try to have some type of plan approved that's general standardized conditions so they could carry out excavations.
And in those cases, when the excavation plan, I think you said 5 years, it might be good for it, it would be more generalized. Does the district proposed general or standardized conditions as to what it would do to limit potential odors during that excavation typically?
Yeah, so the plans have basically mitigation measures like limiting the working face area, covering exposed waste, and then also monitoring provisions as well.
So I think Ms. Morgan walked you through both in the stipulated conditions as well as the contested conditions. The parties are seeking to add a whole lot of sub-conditions to 42. Is that specifically because Chiquita doesn't have any approved Rule 1150 plan?
Correct.
And are the conditions that we're imposing in condition 42, are those specific to Chiquita Canyon's excavations that we know of?
I would say yes, partially based on the West Slope excavation plan that we have seen, I guess, the plan and know what's going to take place.
So is it fair to say that, if they had followed the normal process, they might have had a more general plan with more general conditions? But now we know exactly specifically what they're doing, and so they're going to be subject to more stringent conditions if we're particularly concerned about this particular type of excavation?
Yes.
Thank you. Those are my questions.
All right, members of the board, Ms. Verdugo Peralta.
Thank you. I'm going to ask some kind of overriding questions because of the fact I feel like we're getting into the weeds of this, and I think it's a lot for the public to understand. It's a lot. It's very technical, and I'm not sure that they're going to grasp all of it, but I'm going to try to get to some of it. In reference to the multi-agency group, do you have a list of who those people are?
People wise, I wouldn't know. I'm not necessarily involved in those meetings, but I can say I think the LEA, the EPA, the Department of Toxic Substances Control, and then Cal Recycle maybe, and the water board. I don't know specifically who's involved in what meetings, but I know
Is there a list that's available to the public?
I don't necessarily know that.
Do you know what their purpose is?
I guess to regulate the landfill and try and resolve the issues that are ongoing.
Okay, what about the reaction committee? Is there a list that's available to the public
Of the members,
of the members, who they are, what their background is? I don't, I guess what their title would be.
I believe that would be on Chiquita's website.
Do you know for a fact that it is or not?
I don't know for a fact. It was, I think they're required to post the reports that are submitted under this order on their website, and that was one of the items is list of providing the resumes of all those reaction committee members.
Okay, and what is their purpose?
I guess to provide more technical input on the issues facing the site to make sure they have experts to handle specific things. I cannot really speak to like the general overall purpose.
Okay. In reference to the 240 wells, which is a large number, is the district requiring that number be that high because they're questioning either the protocol or the manner in which they are conducting that getting that information? What's the reason that the number's so high?
240 wells installed, or are you
In general, why did you pick that number?
So we didn't pick a specific number. We picked a density, a well density, and then they mentioned that they have 240 wells installed.
Okay, so in many cases, there's a sampling sometimes when you have something like that. Why, it looks to me, this is how it appears to me, that the reason that there's that many that you're going to look at every single one is because you're questioning their protocol. Is that a fact or not?
Are you speaking for the wellhead,
In
the remote
general,
monitoring
just in
system?
general, just in general.
I wouldn't be able to speak on their protocols or
I
any
know you're
issues
not
with that. Yeah.
speaking on their protocol. I'm just asking, are you picking that number, that total number, because there's something that you're questioning on how they're doing it?
Can I just ask a quick clarification? Are you asking on him to explain why we want that number of wells, period? Or are you asking specifically with respect to the contested conditions, why we want remote monitors on wells?
It kind of both.
Okay, could I ask him to address those independently?
Sure.
So we didn't list the 240 wells we didn't require. It was a well density, and that was based off of this what we saw at the site in terms of lack of wells, and then discussion with other, I guess, personnel in the industry of what might be a good achievable density that would help mitigate the issues.
Okay. I know I had another question. I'm going to leave it there for now. If I have another question, I'll ask the chair.
Mr. Pearman.
First, perhaps you can help me with just an overview of something if you can. My recollection was perhaps back before April with the leachate problem, the thought was substantial dewatering would help resolve that issue to some extent. But a problem developed that essentially there wasn't capacity on site or off site to actually treat the material. And therefore the dewatering had to slow down for a while till that problem was cured. Do you recall that scenario?
Yes, they had to slow down their pumping.
Okay,
Yeah.
but since then, the off-site, on-site treatment capacity has been resolved, and now the full dewatering efforts to control the leachate are in place?
I believe they're still looking at additional disposal options, but in general, yeah, they're installing more pumps in the wells because they can pump out the liquids, and they do have the treatment and storage options on site. But I can't say like long term if they still need additional tanks or treatment or disposal areas.
Okay, thank you.
Go ahead, go ahead.
So you had mentioned there was a time, I guess, in June, for example, there's 4 times more surface emissions in a June report from the reaction area. You recall that?
Yes.
And so was that figure developed from the instantaneous landfill surface monitoring?
That was from the flux study report that they conducted and provided. So they did that one back last August with a report in October, and then they did the March one with a report in June, and comparing them, that was the approximately 4 times, like 3.5, 4 times.
Okay, so that's a different measurement than instantaneous landfill surface monitoring, which is condition 10.
Yes. Yeah, that's essentially measuring with a device on the landfill just the concentration, and then if it exceeds a certain amount, they have to take corrective actions to like cover that area with soil or yeah.
And is that instantaneous, is that different than continuous? Explain what that term means in practice.
Instantaneous, I think I forget, I think it's 500 ppmv is the value. So if they're walking around with that monitor and it exceeds 500 ppmv of organic carbon, then that's an exceedance. Whereas there's also the instantaneous surface sampling, I think, and that one is 25 ppmv. So that's basically walking along a grid of a landfill and collecting data that whole time. And then if the integrated like I guess, average data is 25 ppmb or greater, then that's an exceedance. So just two different ways to measure. One's more of like an average and one's instantaneous exceedances.
But what's involved to do that is really just a person with a device monitoring.
Yeah, just walking. Yeah.
Okay. Um, Now, do you know if you're familiar with the EPA order and the West Slope Excavation Project work plan?
I'm aware of the work plan, yes.
Do you know if AQMD had the chance to comment to EPA before the work plan was implemented?
Yeah, we provided, I think, a couple rounds of comments.
Do you know if the initial work plan has ever been amended?
It has, I believe, once. I'm not aware of another time. So we had the initial and then a revised work plan.
Do you know if AQMD was able to have input prior to the amendment?
Yes.
Now, my sense is that in terms of condition 66 and the remote monitoring system to be installed no later than November 22 on all wells, but then you have this ability to have an extension deadline request that, I'm kind of paraphrasing, that the district proposes that as a solution, but you seem to recognize, at least personally, if not for the district, some uncertainty about its efficacy, and therefore you're giving, by proposed 66F, the respondent the ability to basically come back to you and say, after more study and information, maybe it needs to be changed, et cetera. Is that kind of a sense of what you mean by 66E and F?
Yeah, I think that's generally the purpose. So we don't have any of that information to, I guess, go off of. So that's kind of the interim kind of, well, not interim, but the proposal under this order versus just, I guess, stipulating to Chiquita's language.
Okay. Now, I don't know if this is intentional or not, but the language the district proposed in 66F says to request an extension to the deadline as described in 66D or E. So it doesn't say they could request fewer than all wells to have the monitoring. So I just want to be clear, the kind of carrot you're giving them by its terms, all that says is you can get more time to install them in all wells, but it doesn't say they come back to you with a request to reduce the number of remote monitoring systems on wells. So am I misreading the language, or do you have any thoughts about that, sir?
I think you're reading it correctly. I don't think that's built into that language.
I'm glad you agree with my reading. It's always good. Let's add one more question for you. Okay, that's it. Thank you.
We're going to volley back to Ms. Verdugo Peralta. Yeah, no, we're going to go you and then we'll come back. Yes, ma'am, the floor is yours.
In reference to the work plan, is there something like a Gantt chart that has the list of tasks, that has the estimated completion date, that has costs in it, that is something that the public would be, it would be easier for the public to understand something like that?
I can't say that I saw a Gantt chart myself, but I wouldn't be able to say there isn't one maybe in one of the appendices somewhere, but I did not see one myself.
Okay, and you don't know whether any of your other colleagues would be able to answer that?
I don't believe so unless they look through it currently. Yeah.
Because I would like to see something like that to better understand how long all of this is going to take, more or less what the costs are going to be, the feasibility of it. That gives us to me, in project management, a much better and easier way to look at a project to see how long, like I said, it's going to take. And I think the public is very interested in that because obviously they want this done ASAP. I think we all do. So if there is any information in regards to a Gantt chart, timeline, something like that, I certainly would like to see one.
So I just want to clarify, you said work plan, so I was talking about the excavation, the West Slope excavation work plan, but I'm not sure if you're referring to the monitoring system.
Entirety, in its entirety, all of the tasks that need to be done on this project for all of these tasks to be completed so that the public is better protected from the emissions, whether it's from leachate, whatever it's from, whatever the tasks are. I certainly would like to see how long they're going to take to do all of this.
Can I just ask clarification? This is not in specific any individual conditions. You're asking for a chart essentially for all deadlines within the abatement order?
Yes.
Okay, thank you.
And perhaps it could be a joint effort. Maybe you can work
Yes,
on.
I think if that's your question, you can ask if the district would oppose to, having that added as a condition to develop such a chart.
Chiquita has such a chart. It submits them each month to the Integrated Waste Management Task Force.
So perhaps you can send that over to the clerk and it could be uploaded as an exhibit. So
Yes.
that Ms. Verdugo Proud and others can review. Mr. Bellicapolan, sir, the floor is yours.
Thank you. Dickl, good afternoon. I know it's been a long day for you. I had a question on the West Slope excavation project work plan. Who approved it?
I think in my testimony, I said I am not sure of the approval, but I would think possibly the EPA, likely the EPA.
And maybe LEA and the other
Yeah.
agencies. So they have looked, they have the expertise. Would you agree to review the work plan also?
Yeah, and I guess different disciplines, different organizations, yes.
Within the
Yeah.
different organization. And would you say they're also familiar with the AQMD Rule M50 regarding the work excavation?
I would not know if they're aware, yeah.
But you said you reviewed the work plan.
Yes.
And did you see any deficiency in the work plan?
We did, and we provided those comments back to
And they incorporated it into the work plan?
not necessarily.
Not necessarily. Okay. So if they're following the work plan that has been approved or, tentatively approved by the agencies that are overseeing it and have expertise in that, is there any objection to it?
Are you saying if this is conflicting with that work plan?
Yeah, I mean, if they follow the work plan, that has been approved by other multiple agencies that have reviewed it, and this, what is the issue that you see?
So I think from AQMD's perspective, we have additional items to mitigate the odor impacts to the nearby community. So that was, I guess, the differences.
And what would that be? Because where the slope is, the west slope, that's the reaction area, basically. It's abutting the reaction area, right?
Mm-hmm.
And so they're aware of the issues there in excavating that area because of the odors that it will present. And I think if you look at I don't know if you read the LAA report where they did address that.
I guess I can't speak for those other agencies, but I think the South Coast AQMD would have, so we're the ones who kind of issue mitigation and monitoring plans for excavation. So I think we might have different expertise that those other agencies may not.
But would you also say that the ETLF conditions is something new that the agency doesn't have that much expertise on?
Yeah, I'm not aware of another ETLF in the past year, yes.
Okay, all right. Okay. So I know we heard, and I don't want to go back and forth with the distributors, was not including them, because finally I heard even if a distributor submits the data, you would still review it, correct?
Yeah, I think if there's a real supply chain issue, that would be considered.
So would you have, in light of that, objection to the word distributor added to it?
I think it just depends on the language of the conditions. So we want information from like the manufacturers and vendors of how they're trying to implement these design improvements. So we're not really, I guess, from what we've been told, it's a design and physical compatibility issue with the wells and these monitors.
Okay, I don't want to belabor that point anymore. Then it's already been, or seems to be spent hours on that particular issue. Let me go to one other thing that is well, I'll go to the permitting. You know, when this event occurred, the ETLF and all the storage of the leachate and everything, would you agree that they had to act very quickly and add more tanks, you know, and all that, and connections and so forth? And they potentially, if they had to wait and get permission from the AQMD, you know, would that have been problematic? Because there's an immediate emergency at the site where they had to act quickly, right? So they submitted application, I take it, without operating without a permit, correct? And they paid a high fee.
Yeah, there's, I guess, several, yes.
So they have a sort of quote temporary permit to operate basically until the permit is issued. But you're putting some conditions in the interim until the permit is issued. That's what you're proposing in here.
Yes, so I guess we're only doing that for the leachate treatment system and tanks, not necessarily every unit.
Now, the other, okay, this is what I wanted to ask. And I heard you say, you know, that you agree with the reliability issues of the you know, these temperature sensors and the telemetry and collecting data in those ETLF type area where there's high temperature pressure. And so for me at least, it makes sense to have a pilot to see which equipment will survive in those type of environment. And then before putting it for all 200 and then find out a lot of them are not working and pull them out and do it again. So what is your main objection to doing a pilot?
So we don't have an objection to the facility conducting a pilot, but we think that, I mean, and again, we don't have any information on possible design issues, but we essentially think the pilot could have been done already, and the pilot could be done without being required under an order, and it's extending, I guess, the deadline quite a bit. So I think we want the information to verify that, but our goal is just to have them do this, and then they can resolve the design and engineering issues with their vendors.
So they should have been done already, but they've not. But you want them to do it, collect the data, ensure the reliability of those instruments before, you know, investing in for all the wells. So, but what you want is, it should have been done, but they didn't do it. That's a different situation where we are facing now. And to do it as quick as possible so you can get reliable data, then you can approve, or they can say, hey, this is working, our pilot showing certain type of manufacturers, certain type of devices are working well, certain are not, because as we heard, it's very high temperature and moisture and so all the other issues. So you're not objecting to the pilot, but you just the timeline, not delay the project. Is that my understanding?
Yeah, delay. And then I think some of the, I guess, proposed language is do the pilot and then, I guess, make a recommendation on if the system should be installed. So,
so do you think they're doing this to delay?
I can't say, I can't make an accusation like that. Yeah.
All right, that's fair enough. But you have looked at the EPA, the LEA, the Department of Public, I think it's the LA County Department of Public Health that is the LEA for this site, right?
Yes.
And then you have the Regional Water Quality Board, you have Integrated Waste Management, all the different agencies, plus you have the landfill and the AQMD, of course. So overseeing this project. And and I did notice that they have got a very serious listing that the inventory facility violating state minimum standards. Were you aware of that?
Could you repeat?
They are placed on inventory facilities violating the state minimum standards list. Are you
I'm not aware of
aware
the.
of that? Okay, it was part of the report that was provided. And also it says that here, that at any time, I think they have the authority to shut this facility down if they're not, you know, issue a compliant to schedule. And then I did see some of the language, if they continue to exceed that standard, that they can actually,
You have a
I'm gonna
question?
have to clarify that this witness can't speak to any other agency's legal authority. So I do understand that the respondent did put those other orders from other agencies, but he can't testify to what another agency might legally have the authority to do.
okay, fair enough. But I just wanted to, there are other agencies that are doing oversight and maybe sometimes they are competing requirements, you think, or when you meet together, you ensure that everything is sort of, competing requirements from all the different agencies when you have your weekly or monthly meeting?
So I don't necessarily meet in those meetings, and maybe that's I guess, a legal question of if our requirements, I guess, conflict with the other agencies, but I think it's likely that we try not to conflict.
Okay, all right. I have no further questions. Thank you.
Thank you. Any additional questions? Okay, we can take a 5-minute break if you're so inclined, or we can go right ahead into your next witness. What do you prefer?
We can go into our next
Okay,
witness.
very well. Off we go.
Are we taking 5
Uh,
minutes?
No.
Oh.
No, I think folks need 5 minutes. We'll do
Oh,
5 minutes. Hold
sorry.
on.
Okay.
Hold on, 5 minutes. Okay, Mr. Kevin, we're gonna take 5 minutes, sir. We're off the record. All right, we're back on the record. We're back on the record at 3:26 PM. We went over and checked the Zoom. No one had their hands raised. So what we're going to do is allow testimony to go on. And if their hands are raised and we can't get to you today, we'll get to you Tuesday. All right. So the floor was held by,
Somebody just raised their hand, it looks like.
okay, so why don't we go ahead and we're going to take this one individual, then we'll roll into the district's questions, district's examination of their witness.
Hello, board members. My name is Lynn Planbeck. I'm with Santa Clarita Organization for Planning and the Environment. I did not speak on Saturday, but I was sworn in this morning, and then I listened to most of the meeting. I had to go out for a little while. But I just wanted to say that we did, as was already stated, pass a resolution calling for the landfill to be closed due to violations,
yes.
but also
Mhm.
also that there be an emergency declaration to help the community folks that are suffering from all these adverse impacts. But I wanted to say that the reason we really support the staff's proposal of closing it down is because we've worked on this landfill for 2 decades as a group, as a community group in Santa Clarita Valley. We've been around for 35 years, so we've been watching this for a long time. And we were involved in the 2017 approval. And in that approval, there were certain conditions of approval that the Board of Supervisors was supposed to institute. One of them was condition number 68, that said that they were supposed to have community monitoring wells and they were supposed to have continuous monitoring of VOCs. Well, 6 years later, that never happened. It never happened until the board ordered it to happen. And we were told there was no way that they could do continuous monitoring for VOCs because that wasn't scientifically possible, which, as you well know, that they can do it on oil wells. They certainly could do it here. So we really are concerned that they are not, that they are stalling. They're doing the same thing with the water monitoring well. And the more they stall, the less data you have. So we're really concerned about the water monitoring well too, which is of course not your purview, but it's exactly the same situation. Somehow they can't manage to put it in. We've asked for that for 2 decades. But I just think that it's really important that there be some cutback of the trash that's going in there because that's probably the only thing that would really persuade them to do what they are supposed to do. And they are really bad actors. They don't do what they are supposed to do. I went to the Board of Supervisors since 2017, almost monthly, asking for where those monitoring wells were. And of course, they were supposed to do an entrance. There's a condition about not having trash on the roads and dust on the roads. That's still happening. So whatever is going on with the Board of Supervisors, they don't seem to be able to enforce. I guess these folks are just too big to fail. And so we are really counting on the South Coast AQMD regional water quality to make sure that some of these conditions that they were supposed to abide by are in fact enforced. So thank you for your hearing and thank you for moving forward with this.
Okay, why don't you stay on the line for a second, ma'am? Just why don't you spell your last name for the record? We have a court reporter here. So
Okay.
I assume you're testifying on the record, correct? And you're
Yes.
comfortable with being questioned by all
Yes.
parties? Okay, so your name is
Lynn
your first and
Planbeck.
last.
Lynn, Lynnne, Planbeck, Plambeck, Santa Clarita Organization for Planning and the Environment.
Okay, so the petitioners are going to ask questions if they so desire.
No questions from the district. Thank you, ma'am, for your testimony today.
Respondents?
Just perhaps a couple quick questions, maybe only one. Ms. Plumbeck, do you live near the Chiquita Canyon landfill?
I live in Newhall, but we have worked with the community for many years. And I think watching what has happened and being involved, we do have board members that live in Castaic and board members that live in Valverde. But I don't think that's actually a legitimate question, because I think anybody that is watching what's gone on here would want to have the AQMD enforced.
No further questions.
Members of the board.
Actually, a question more for AQMD. Both at Saturday and in her testimony, she said she hopes we issue an emergency declaration. And I didn't know what that meant in our context. I know I've discussed with the EPA and the West Slope and the problem. So is there something that we're being asked to do, or do we have a power for this emergency declaration that's been mentioned twice now?
No, sir, we addressed that to the governor, state of California. That
I
was
wasn't, not Miss, I'm asking district council. Hold on.
The district does not believe that you have independent authority to declare an emergency with respect to Chiquita Canyon landfill, but that's independent of the order for abatement.
Any additional questions of the witness? All right, thank you. Thank you, Ms. Planback. All right. The petitioner side.
Thank you. The district calls Angela Shibata, and she needs the oath administered.
Okay. Please raise your right hand. Do you solemnly state under the penalty of perjury that the evidence that you shall give in this matter should be the truth, the whole truth, and nothing but the truth?
I do.
All right.
Thank you. Ms. Shibata, could you please state and spell your name for the record?
Good afternoon. My name is Angela Shibata. That is Angela. Last name Shibata.
What is your position here at the district?
I'm the Senior Air Quality Engineering Manager that oversees the waste management permitting team.
And how long have you been employed at the district?
16 years now.
And how many years have you worked in the waste management division of permit engineering and
All
permitting?
16 years.
Okay. Are you familiar with Chiquita Canyon landfill and this order for abatement?
Yes, I am.
Thank you. Let's turn first to the contested conditions 66 and the deadline in 66E that the district has proposed of November 22nd, 2024. Are you familiar with this condition?
Yes, I am.
Could you explain where we got the November 22nd deadline? What is that based on?
So in advance of I believe it was the March and April hearings, we were looking into a condition like this to monitor the reaction area wells and to make sure that the area where there's the reaction area, where there's elevated temperature, that the parameters of temperature and pressure were monitored, since we were aware that that kind of system does exist and can be created through various vendors. Because of that, I had reached out to different manufacturers and vendors and asked about elevated temperature landfill systems for these kinds of remote monitoring systems, and if they are possible, and then kind of what the scale and scope of those would be, understanding that these are likely going to be custom-built systems due to the differences in each individual landfill's needs, and what the goal of these kind of monitoring systems is. So as some of the feedback I had received from these different vendors, manufacturers, was providing estimates for lead time. And for, it was approximately 200 devices or 200 wells. The lead time that was estimated for these custom systems was anticipated to be 8 to 12 weeks. So we used that value in like informing in the kinds of timeline that we would recommend for proposals in this order for abatement set of conditions.
Thank you. So 12 weeks from now would, give or take, be November 22nd, 2024. Is that correct?
Right. We used that value as an estimate for this time frame.
Thank you. Are you familiar with the April 19th, 2024 report titled LFG Wellfield Automated Remote Monitoring Plan? It's Exhibit EE in the record.
I am.
Okay. Based on this report, did Chiquita's consultants determine that it was recommended to install pressure and temperature remote reporting, or I'm sorry, remote monitoring systems?
They did not have any recommendations indicating that it should not be deployed or that it could not be deployed. It basically gave recommendation on the kind of pressure transmitter for the pressure system and installation of the 3 high temperature thermocouples encased in the stainless steel tubing jacket. So they made recommendations on how it could be done for pressure and temperature, which were the 2 required parameters according to condition 66.
Did they recommend further study before implementing those 2 items?
Not in particular for those 2 items. They did mention recommending a pilot study in general, and they also had recommendations of other parameters that were listed as things that could be looked into, such as gas composition, flow, liquid level, wellhead control valves, and they had some recommendations where they did not recommend those, which we do understand that's what they had made that recommendation for, and do also acknowledge that those other parameters were not required under the OA condition 66.
Did you hear the questions posed by Chiquita's counsel to Mr. Dickl regarding potential concerns with this remote monitoring system?
Yes.
And are any of those concerns substantiated by this report that was prepared by Chiquita's consultant?
The line of questioning was really about things that were new information to us. There were some, recommendations, like I mentioned, where they don't believe it's viable for flow monitoring for the gas, but there wasn't evidence that was provided. The report really talks about SES engineers' recommendations and acknowledging that there are vendors, but there was no information provided, at least as far as I can see, based on those vendors, based on those manufacturers, what evidence there was, what communication there was, what findings they had, if those entities had proposed solutions or, had recommendations for others that could provide proposed solutions. And so this report really didn't get into the details that were asked during questioning of my coworker's testimony.
Separate from this report, has Chiquita provided you with any evidence to support these concerns?
No.
I want to turn to the idea of a pilot study on a limited number of wells. Why don't we think a pilot study is necessary?
As my coworker had indicated, we're not opposed to the idea of a pilot study, but we don't want that to inhibit the need for this system to be installed. And so our concern is if you are doing a pilot study that has a recommendation maybe to not install this, that's not enforceable. That's not ensuring that this is being implemented to monitor the temperature and the pressure of that reaction area, which is the big concern that we have at this landfill. And so, we want to make sure that this condition ensures that they will install this, since there weren't any written documentation or concerns with evidence supporting those claims aside from just, the recommendations from SCS in this report.
And you kind of got into this, but I just want to ask the specific question. What would be the disadvantages of allowing them to conduct this pilot study?
The disadvantage is not being able to get that real-time data in a timely manner, not moving forward with proposed solutions on any kind of engineering concerns, or even if it was a supply chain concern, where that would be delaying those issues rather than moving forward to resolve this monitoring concern. And I want to clarify that this is a real-time monitoring system. So if something is happening where yes, they're doing temperature monitoring and pressure monitoring according to rule requirements in the OA, but that won't be real time. So if there's something happening in the reaction area that is more responsive and would require a more real-time response from the operators, we believe that a system like this would better inform them as well as the regulated community on those changes at the landfill.
Thank you. I want to turn to the proposed conditions 66C and D, in which Chiquita has proposed to add distributors in the list of vendors and manufacturers. Can you explain why we are opposed to including distributors specifically in those two conditions in that location?
We're opposed to including distributors because we're not prohibiting them from contacting distributors. But since, just based on the line of questions, as well as some of the recommendations that were summarized, it sounded, as my coworker had indicated, that there are engineering and specification and design concerns. And so we wanted to ensure from an enforceable condition perspective that just contacting distributors that would be more kind of the sales representatives and availability of materials rather than are we overcoming engineering solutions. So we didn't want to replace an engineering solution with simply a supply chain or procurement issue.
So we wouldn't be opposed to them talking to distributors in addition to at least 3 reputable vendors or manufacturers. Is that accurate?
Absolutely. It's really about maintaining the minimum requirements from the engineering design specification concerns that were raised, but not, we would welcome any other additional information that would indicate the viability or other concerns with the implementation of this system.
Thank you. Okay, I want to turn now to condition 86. And the condition that's labeled on the district's side, G, and on Chiquita's side, F. Can you discuss with some more specificity what the district is asking for with regards to the monitoring and testing in this condition?
So this condition, as the district has it written in the proposal, is sample ports shall be connected to the liquid treatment system, leachate tanks, solid handling tanks, and any other equipment associated with the treatment or storage process, and shall be monitored at least daily. And then it lists what it needs to be monitored for. Just want to make sure we're on the same page here. And there was discussion about whether this should say flow meters, and we had indicated, yes, we would agree that it should be sample ports and flow meters because one of the parameters to be measured is flow rate, which you can't do without a flow meter. So the concern with this is through the line of questioning, it had indicated these are the kinds of parameters that are typically monitored at a wellhead, which is correct. Some of them are parameters that you would typically monitor at a wellhead. And there are hundreds of wells and wellheads that are monitored. And typically there are instruments that can be used to sample and take readings of those values across all those wellheads, which is more than the, potentially 200 tanks that we would see for the leachate treatment tanks in of themselves. So I don't necessarily believe that that would result in, I think it was 240 or, hundreds of samples that need to be sent to a laboratory. I would be interested if that's what they want to do and propose. But typically when it comes to sampling and monitoring, we would also work with our monitoring and analysis division to make sure that those are being taken appropriately using appropriate methods and instrumentation.
Thank you. What is the advantage of a sample port?
So a sample port allows you to take a sample from that port and not necessarily having to open up a whole system. So I think in some of the testimony given by our compliance and enforcement folks, there were also some exhibits of tanks that were open to atmosphere, not covered. And that is a huge concern for South Coast AQMD because that is a source of odorous emissions, which is affecting the community, as we know, based on all these different Rule 204 or 402 violations for nuisance. And so you don't want to have to open up a large, possibly 20,000 gallon tank of very odorous material just to take a sample, especially when you need to do sampling anyway for EPA requirements or water board requirements or other agencies to make determinations on if it's hazardous waste, if it's not hazardous waste, if it's exceeding certain thresholds or action levels for those regulatory requirements, let alone our own. And so from a nuisance odor concern, those sample ports are critical to avoid those kinds of emissions, in addition to ensuring that it's being taken at an appropriate location. So once again, I would give nod to our monitoring and analysis division on typically there's recommendations on where you would place those sample ports and if that would ensure that the sample is appropriate representative sample.
Thank you. And I think you already covered this, but just to make sure it's clear, would a sample port be helpful to prevent fugitive emissions?
Absolutely.
Thank you. Did you hear the questioning of Mr. Dickl regarding the timing of installing sampling ports on all equipment on site that requires sampling, as well as specifically the landfill gas treatment system?
Yes, I did.
So in that testimony, Mr. Dickl said he wasn't sure if there were other pieces of equipment other than the landfill gas items specifically discussed in contested condition 86 that would trigger the requirement in the non-contested condition 76. Could you explain why we also want to ensure that we have the condition that says respondent shall install sample ports on all equipment on site that requires sampling?
Yes, so as I just mentioned, there are a lot of different regulatory agencies involved with this facility and the ongoing reaction that's causing, nuisance odor among other concerns. So we at South Coast AQMD may not be aware of every single point that requires sampling, but we want to ensure that any sampling that needs to be conducted, whether that's for water or air or solids or other kinds of substrates, that those are done through appropriate sample ports to avoid having potentially a big plume of odorous emissions just for doing sampling that they're required to do. So this is really specific to an AQMD concern for nuisance and odor, as well as just ensuring that they're able to sample where they need to for our own requirements as well.
Thank you. I want to kind of stem off of that one a little bit on you had mentioned other agencies' potential requirements. Do any other agencies have regulatory authority over nuisance?
Not that I'm aware of. This is a South Coast AQMD requirement that we need to uphold that is in our rules. And so that's why this is the most important for our agency. And we have specific conditions crafted to that other agencies may not be as well versed in or in both a recommendation, implementation, and enforcement aspect.
So is the nuisance issue the primary issue that we're trying to get at in terms of the differences between the work plan that's been approved and the requirements we're asking for in this OA?
Yes.
Are you aware of EPA's unilateral administrative order?
I am.
And do you know if that administrative order requires that Chiquita comply with the order for abatement issued by the AQMD hearing board?
It is my understanding that it does require compliance with the order for abatement from South Coast AQMD's hearing board.
Thank you. And have you reviewed the work plan for excavation of the West Slope?
I have.
And is there anything that we are requiring that would be in conflict with that work plan?
I'm not aware of anything being in conflict with. I am aware that the requirements that we're proposing through this order for abatement are more stringent and can be more stringent or require some additional information beyond some of the equivalency between the work plan and the proposed conditions.
Does the work plan prohibit more stringent requirements?
It does not.
And would complying with any of our conditions result in a violation of the work plan, as to your understanding?
I'm not aware of something that our proposed conditions would result in a notice of violation.
Thank you. I want to turn now to condition 42. Regarding the cover for the, specifically as it relates to the West Slope excavation. Sorry, let me get to my right. Do you believe that, are the requirements discussed in 42, I guess it's listed as little I. Are these requirements regarding final cover or interim cover?
These are not final cover requirements. These are basically requirements that are mitigation measures for odor and other kinds of emissions. And so the thought process with a lot of these conditions, which we tend to impose through Rule 1150 excavation plan approvals and conditions, is to limit these odoriferous sources when they're causing, when there's more emissions, when they're causing nuisance or potentially nuisance or exceeding certain kinds of emission thresholds.
Thank you. So the record's clear, it's 42N little I. Do you believe these cover requirements would significantly extend the time needed to complete the West Slope project?
I can't say that I anticipate this significantly exceeding the timeline or causing significant delays to the timeline. Based on my understanding of other landfills that also have had extensive excavation requirements, maybe sometimes even in response to nuisance level concerns or other kinds of concerns, that typically you would cover things as you go to kind of help limit that exposure. Not just keep everything all open the entire time when you're not actively excavating in those areas. And I believe that this condition also acknowledges that. Let me refer real quickly. Perhaps I can't do that right this moment, but it's really for
42N is the first one is the one that refers to the cover, and then 42N little I we'll talk about in a moment has to do with the work phase.
So 42N requires landfill materials and refuse which have been exposed to atmosphere as a result of the excavation, which have not been excavated and relocated for burial or transported offsite, shall be immediately not to exceed 30 minutes, safety permitting, covered with, and then it lists a bunch of different kinds of cover mechanisms. And this is whenever excavation is not actively in progress and at the end of the working day, so that no portion of landfill material and refuse is exposed to atmosphere. So this is not, I'm actively digging into something and therefore I can't cover it, or I'm actively placing rocks as part of my excavation activities. This is when excavation is not taking place. And so we believe that this 30 minutes with safety permitting should be sufficient. Additionally, for some of the requirements for when they do need to bury the material for offsite or rebury at the facility, that has a longer timeline than this. So we would believe that if you're not just covering, you're covering it, you're putting in a truck, you're sending that truck up to an area to dispose, having a longer timeline because you're doing more than just covering, then the time frame here should be sufficient because it's much less steps involved with simply covering when there's not excavation occurring.
Thank you. And now let's turn, I apologize for the mix up between the sections. Turn to the requirement that the work phase shall not exceed 1,000 square feet. And did you hear the testimony or the cross-examination by Chiquita's attorney of Mr. Dickl asking about how this would apply to the West Slope excavation, that our condition would ask that it apply to the West west slope excavation, whereas Chiquita's proposal is to exclude the west slope excavation. Did you hear that?
Yes.
So what is your understanding? Did you hear the question regarding the fact that this 1,000 square feet requirement would cut the working face of the west slope excavation by a third?
I did hear that.
And is this accurate to your knowledge?
I'm not familiar with the calculation involved to reduce it by a third. So I don't think I can speak on that particular value.
Okay. To the extent that any of these requirements does extend the time necessary to complete this excavation, do you think that it is worth it to reduce the potential odors impacting the surrounding community?
I think it's critical to use these mitigation measures, to use these conditions which have been utilized as part of many of our standard conditions because they've been demonstrated to work, to prevent nuisance, to mitigate nuisance, which is even more critical with this west slope excavation, which is butting up against the reaction area where we've heard testimony that the reaction odors and associated leachate and drillings material is very odoriferous and is an odor that has been traced back to the community many times. And so it is our concern that if you exempt these conditions specifically to an area which we believe has the potential to be even more odorous, that it's critical to include these conditions and not have them be exempted due to that odor potential. Does that mean that that will absolutely happen no matter what? That is uncertain. But we do recognize that there is a lot of odor potential in this area butting up against the reaction area, as well as we had heard that this area is impacted by leachate and other kind of landfill liquids, which also are odorous. So this is not your typical, I'm excavating an area with some trash and I'm covering it up. This is even more of a higher potential for odors, and it's all the more critical to have these conditions be implemented for to prevent and mitigate public nuisance for the safety and well-being of the surrounding community.
So you are basing your belief that these requirements are feasible on your experience and knowledge of working with other landfills and them implementing similar measures. Is that accurate?
I believe that's accurate.
Thank you. No further questions.
Thank you very much, Ms. Riker. And folks, I hate to have to land the plane, but it's 3:59. We landed with very little turbulence today. We're going to recess until Tuesday, August 27th at 9:30 a.m. Prayerfully, we will in fact close out at 2 p.m. We have a hard stop as a member of the hearing board with personal matter to tend to. 9:30 to 2 o'clock, we should be able to bring this to close.
When you say bring it to close, do you mean all 6 of Chiquita's witnesses? Because we think we'll need a couple of extra days.
But, and if that's the case, then I'm more than willing. I want to help us expedite it, but if you need a few more days, not a problem. We're here.
Okay, and I don't know if it's okay to mention, but we also talked earlier about the documents that we talked about, and the district is getting back to us in their proposed timeline, so we would request one hearing day after we've received the documents, so we have time to review.
Hey, all is good. We just didn't want to get off into calling for subpoenas and holding hearings on subpoenas, so let's try to find a way to work amicably. All right. Okay, folks, well, we're recessed at 4 p.m. until Tuesday, August 27th, 9:30 a.m. We're off the record, Mr. Kevin.